Tanshri Tanshri, Dato Shri Dato Shri, Dato Dato, distinguished guests, ladies and gentlemen, I would request you all to be seated as we will be commencing the ceremony shortly. Please keep your mobile phones on silent mode throughout the entire event. Before we start the ceremony, we would like to take this opportunity to thank our sponsors, Marvin Kwai and Associates, Christopher and Lee Ong. We would also like to express our utmost gratitude to the supporting organizations for our inaugural Asian Sports ADR Summit 2024. The Malaysian Olympians Association, the Malaysian Institute of Arbitrators, Chartered Institute of Arbitrators, Malaysia branch, Japan Sports Law Association, the Australian and New Zealand Sports Law Association, and the International Association of Physical Education and Sports Incorporated. Ladies and gentlemen, please rise as we announce the arrival of our guest of honor, His Royal Highness Tunku Imran Ibni Almarhum Tuanku Al-Haj. His Royal Highness Tunku Imran, Honorary Member of the International Olympic Committee and Patron of SLAM, Datuk Sundra Rajoo, Director of the AIAC, and Mr. Sharguna Raj, President of SLAM, Honorable Justice Dato Anand Punudurai, High Court Judge of Penang, Tanshri Tanshri, Dato Shri Dato Shri, Dato Dato, distinguished guests, ladies and gentlemen, a very good morning and a warm welcome to the Asian International Arbitration Center. Today's summit is focused on promoting efficient and effective dispute resolution in the field of sports. This summit aims to bring together key stakeholders from the sports industry, legal experts, arbitrators, and professionals to explore and discuss the latest trends, challenges, and advancements for the resolution of sports-related disputes. Attendees can expect enlightening conversations, real-world case studies, and invaluable perspectives from our esteemed speakers. With that said, on behalf of the AIAC, we are truly pleased and honored to be able to welcome and host all of you on this momentous event today. To begin the event, we would like to call upon the Director of the AIAC, Datuk Sundra Rajoo, on stage to deliver his welcoming remarks. Please welcome Datuk Sundra Rajoo.
Your Royal Highness, Tan Sri Tunku Imran, Yang Arif, Dato Anand Punudurai, and Yang Berusaha, Mr. Seri, President of SLAM, distinguished guests, ladies and gentlemen, a very good morning and welcome to Bangunan Sulaiman and to this Asian Sports ADR Summit. I just want to start off is that the journey to this point started in 2010. And it actually starts with His Royal Highness Tunku Imran. I remember I was appointed as director in 2010 in Jalan Conley, and suddenly Vinayak reaches out to me through Audrey. And then Audrey says, look, Tunku Imran wants to see you. You don't mind that I call you Tunku Imran. And I was told to attend a meeting. And that time Tan Sri was actually president of the Olympic Council in Malaysia, and more importantly, he was also a council member in the international, I mean, the World Olympic Committee. So I was called in, and of course, eager. I was very, very eager. I was awed by Tan Sri, and then Tan Sri is telling me, look, you have to tie up with CAS, the Court of Arbitration Sports in Switzerland. And then he said that he will arrange for the tie-up. And true to his word, we then signed, he introduced us to Matthew Reap, who's still in CAS, Secretary General of, and we did the tie-up, which exists until now, that we are the alternative hearing venue for CAS in Asia. That time was in Asia. And then I suppose there are more hearing venues now being set up. So from then on, started this idea, how do we foster sports? How do we resolve disputes in a more efficient manner? And I actually extend my heartfelt thanks, particularly to Tunku Imran and everyone here for being here today. You can see how it has evolved. We have done particular things. In October last year, which we have been talking about, and I was telling just now we were discussing that one of the things that we decided to do this time is to go ahead and create the structures. Before 2018, the way we did it was we waited and we tried to get approvals, and then we wait how to tie back with the government and other structures, and we did not move. If you remember, many of y'all were trained as sports law arbitrators. In sports law and in arbitration, we had highly specialized training because the idea was to create that cadre of arbitrators who could be empaneled when we create the Asian Sports Tribunal. The Asian Sports Tribunal, actually, the idea started much earlier when we were trying to create this structure. So when we did the Asian Sports Tribunal idea, we had to have the panel of arbitrators. So AIAC, that time KLRC, organized a number of sports law courses. And I think young Arif is in the first batch. First batch, I mean, he was great interest. He was there in the first batch. He's qualified to be on our panel today. Of course, he's a judge. Maybe he will not accept it. We will invite, but it's up to him. But I think we are being actually quite open. So we have decided that we will invite all the people who were involved in reaching this point, particularly the people who were trained. So in the sports arbitration rules is actually the Asian Sports Arbitration Rules, again, is a pioneering effort by the center, and it follows a number of ideas. We want to create a special set of rules which is arbitration based for sports, and it is applicable universally. So and then it is arbitration in nature, so that it uses the Arbitration Act, and we are also able to attract any disputes. So we want to start locally, then try to attract the disputes from outside. That is why we call the Asian Sports Arbitration Rules. Today, we also launched the Asian Sports Tribunal. The empanelment occurs today. I think number of y'all have received the certificate, but we try to actually set it up today. And then there is a significant moment. There is one person who will represent the panel, and he will be Tan Sri will be presented with that as the number one. Now, sports rules. What did we actually put in the sports rule? It is designed to actually resolve all kinds of sports disputes, whether they are contractual or not, contractual, selection, eligibility, everything that is pertaining to sports. We are even looking at doping, but doping is under WADA, so we have to be a bit more careful on that. Now, the procedure itself is faster. For selection disputes, it will be done very, very fast. That means it will be, in fact, the rules are so flexible that we can do almost like a quick decision. At the same time, we can go back to other kinds of things. So the procedure can be actually tailored. Now, the summit itself, I think you know the program. We have 3 sessions, and we are going to go through the ambit of sports and arbitration. So I won't go into that. We are also looking at ethical rules, code of conduct for the panel, and we have started to do all that. So I want to actually talk about collaboration. The next step after the launching of these rules and the panel will be, most important is we have to increase awareness. The second part is we have to start to collaborate. We will then now start talking to the various sports bodies to incorporate our agreement. And of course, you know, we have to talk to also the government and the associations to agree to use the rules. So it's a start. So the structure is there. It is a start. And I actually thank again, particularly all of y'all, and particularly Tunku Imran, for starting this idea in 2010. And now it's 2023, 23 years. Is it 23? 13 years. 13 years. 13 years to get where we are today. Thank you so much.
Thank you, Dato, for your opening remarks. Distinguished guests, ladies and gentlemen, we would now like to call upon His Royal Highness Tunku Imran, Honorary Member of the International Olympic Committee and Patron of SLAM, to deliver His Royal Highness's keynote address.
Well, a few familiar faces I see. Anyway, it's good to be back here in the Bangunan Sultan Sulaiman with the AIAC people. As Datuk Sundra Rajoo said, it's been a long time, this crusade to get ADR really accepted by the sports world here in Malaysia, but I'm sure we're getting there. And as Datuk Sundra is saying, let's do it, and then ask them to join, rather than persuading government to actually do it first. So I think that is now the strategy. Well, anyway, distinguished guests, Judge, Datuk Sundra, SLAM President, and all the other distinguished people that are here today for this summit, as it is called. A very good morning, and I hope that today there's going to be some, good deliberations and some ideas, and perhaps some innovative ideas, because we stand at the crossroads of tradition and modernity here, where the age-old spirit of competition meets with the innovative forces of the 21st century. Today's Asian Sports ADR Summit is not just a congregation, it is a testament to Asia's burgeoning potential in the world of sports, unified under the banner of unity, integrity, and innovation. As we chart the course for the future, we must acknowledge our audience today, prominent lawyers, government officials, sports leaders, arbitrators, celebrated athletes, and the vibrant young professionals. Your presence signifies the collective intellect and passion poised to redefine Asian sports law. In the vast expanse of our continent, from the majestic Himalayas that touch the heavens to the myriad islands scattered like jewels across the Pacific, our stories of sport are as diverse as the very tapestry of Asia itself. Every athlete, every competition, every cheer that rises from the throngs of fans carries with it the distinct echo of our varied cultures and histories. Yet, within this beautiful kaleidoscope, we find a singular, pulsating heartbeat, a shared ambition that resonates through the roar of stadia and the silent anticipation of the starting line. It is the ambition to transcend boundaries, to unite under the noble banner of sportsmanship and fair play. The Asian Sports ADR Summit emerges as the embodiment of this ambition. This is not a mere conference on sports, rather a symbol of unity. As our athletes and players strive to glorify the nations on the field, all of us here today play pivotal roles to foster betterment of the sports scene in Asia off the field. This unity is our beacon, casting a light so bright that it reaches the furthest corners of the world. It proclaims that Asia is not just a participant in the global dialogue of sports, but a leading voice, an advocate for a world where every athlete can compete with the assurance that their rights are protected, that their efforts are judged fairly, and that their victories and defeats are honored with equal respect. When we speak of the Asian Sports Arbitration Rules, we speak of a pioneering initiative that is much more than a framework. It's a bridge, mighty and resolute, spanning across choppy seas and rugged terrains, connecting athletes, officials, and nations in a covenant of integrity. It is the very embodiment of our unity, ensuring that while we may compete with fervor, we remain united in our quest for excellence and equity in sports. This unity in ADR is a powerful force, a clarion call that echoes across playing fields and boardrooms, urging us to look beyond the competitive zeal and see the larger picture of what we can achieve together. It is about harnessing our collective energies to ensure that every player, every team, every nation has a fair chance to succeed, to make their mark, to celebrate their moment under the sun. The vision of sports transcends the boundaries of our continent. It is not confined to addressing the immediate challenges we face within our sporting communities. Our gaze is set on a loftier horizon to elevate the very standards of sports arbitration and ultimately fair play on the global scale. We do this not through mere words, but through actions that are as transparent as the morning sky. Every decision made, every rule formulated, every process implemented under the AIC's aegis is a reflection of this unwavering commitment to integrity. In the realm of sports, integrity is more than a principle. It is the very essence that fuels the spirit of competition. It's about embodying values that transcend the boundaries of the playing field. In Asia, our unwavering commitment to integrity is the bedrock upon which our sports institutions are built. Through our ADR mechanisms, we are charting a course where disputes are resolved not merely with efficiency, but with a profound respect for fairness and impartiality. In Asia, our approach to innovation in sports and ADR is not just a concept, it's a collective journey to the forefront of global leadership. This journey is fueled by a unique blend of cultural wisdom and cutting-edge technology, where diverse nations, including Malaysia, play pivotal roles. This Asian narrative of innovation is a testament to what we can achieve together by embracing technological advancements and being innovative. We are collectively redefining the standards of sports law and ADR. Our shared goal is clear: to place Asia at the vanguard of sports arbitration, known for its commitment to justice, efficiency, and forward thinking. As we advance in this journey, united in our vision and efforts, Asia's role in shaping the future of sports and ADR is not just a possibility, but an emerging reality, a legacy we are all part of creating. Ladies and gentlemen, here I want to acknowledge that AIAC stands at the forefront of this innovative journey, all in its own capacity. By meticulously developing and refining sports-related legal frameworks, it is not only keeping pace with the dynamic landscape of Asian sports, but also setting a precedent for excellence. Its efforts in crafting fair, comprehensive sports rules and regulations ensures the welfare and rights of athletes are at the forefront. Also, the Sports Law Association of Malaysia, SLAM, although a very young organization, is there to enhance the capability of sports lawyers in the region and to be an advocate for justice and fair play at all levels of sport in Malaysia. And you, ladies and gentlemen in the audience, your own legal diligence contributes significantly to the safe development of sports, fostering an environment where athletes can thrive and the spirit of fair competition is upheld, further solidifying Asia's position as innovators and leaders in the global sports arena. Let us reflect on the journey we are embarking upon together. The path of innovation in sports and ADR in Asia is not just a road we travel, it is a legacy we are building. Asian nations are at the forefront, pioneering advancements and setting benchmarks that resonate across our continent and beyond. Their commitment to integrating technology in sports arbitration is a beacon for us all, illuminating the way forward. In embracing the spirit of innovation, we are not just participants, we are leaders. We are setting the stage for a future where Asia is not just a player, but the trailblazer in the global arena of sports and ADR. Our collective efforts, our shared visions, and our unwavering commitment to integrity, unity, and innovation are the cornerstones of this journey. Together, we are redefining the landscape of sports law and dispute resolution, ensuring fairness, efficiency, and access for all. When we part ways later today, let us carry this message in our hearts and minds. Let us be the ambassadors of this change, champions of a future where Asia leads with innovation and justice. The path ahead is bright, and together we'll be writing a new chapter in the history of sport and ADR, a chapter where Asia stands tall, proud, and at the forefront. In the word of Bill Bowman, the co-founder of Nike, victory is having done your best. If you have done your best, you've won. So, ladies and gentlemen, let us do our best for those who have done their best, so that we may win together. Have a good conference and deliberation today. And to all our visitors from overseas, thank you in advance for your contribution to this Asian Sports ADR Summit. Thank you very much.
Thank you, Your Royal Highness, for your keynote address. We kindly request Your Royal Highness to remain on stage for the launch of the Asian Sports ADR Summit 2024. I would also like to invite Datuk Sundra Rajoo and Mr. Sri Sargunaraj and Justice Dato Anand Punadurai to join His Royal Highness in officiating the launch of the Asian Sports ADR Summit 2024. We humbly invite Your Royal Highness to light the symbolic torch carried by Malaysia's pride, Mr. Muhammad Arif Afifuddin and Ms. Noraseela Khalid. And with that, we would like to thank Your Royal Highness for officiating the launch of our Asian Sports ADR Summit 2024. I now request Datuk Sundra Rajoo to present His Royal Highness with the first ever empanelment certificate for the Asian Sports Tribunal. Thank you, Your Royal Highness and Datuk Sundra Rajoo. Ladies and gentlemen, behold our journey. The Asian Sports Arbitration Rules were unveiled on 6th of October 2023. This is the latest addition to the AIAC's new suite of ADR rules. We are proud to share with you this initiative and to explore how parties may avail themselves of the many benefits of the sports rules. I would now like to invite my colleague, Mr. Sanjev Sharma, Case Counsel at the AIAC, to share some insights on the Asian Sports Arbitration Rules. Over to you, Sanjev.
Thank you, Vishnu. Your Royal Highness, Tunku Imran, Datuk Sundra Rajoo, Mr. Sri Sargunaraj, Justice Dato Anand Ponudure, distinguished guests, ladies and gentlemen. I stand before you today to embark on an exploration of the Asian Sports Arbitration Rules through the distinctive lens of the Asian International Arbitration Center, the AIAC. So if you did not manage to capture the QR code displayed earlier, you still can. For those of you who don't have the hard copy of the rules, you can access the soft copy here. So these are some of the highlights of the Asian Sports Arbitration Rules. Now, our journey commences with the core highlights of the rules, which are neutrality, flexibility, expediency, and expertise. These guiding principles reflect our unwavering commitment to providing a fair, efficient, and expertly administered mechanism for resolving sports-related disputes. The Asian Sports Arbitration Rules stand as a testament to the AIAC's commitment to advancing sports alternative dispute resolution, or ADR for short, in the region. This initiative was conceived to address the unique requirements of the sports industry, aligning seamlessly with international standards. Central to its formation is a diverse panel of experts from different jurisdictions globally, ensuring a comprehensive and well-informed approach to dispute resolution. Parties, recognizing the dynamism of the sports world, are granted the flexibility to substitute an existing arbitration agreement with our model submission agreement, ushering their dispute into the specialized realm of the Asian Sports Arbitration Rules. The scope of sports-related disputes under these rules is expansive and forward-looking. It covers any financial or non-financial aspect of sports performance or development, a breadth that includes any activity or matter related or connected to sports, as our director has pointed out earlier. This comprehensive scope ensures that the Asian Sports Arbitration Rules can effectively address the evolving nature of sports and its myriad facets. A hallmark of the Asian Sports Arbitration Rules is a streamlined procedure designed for efficiency. The rules mandate a focused approach to written submissions, limiting them to the request, the response, and any defense to counterclaim. These defined parameters ensure that the arbitration process is swift, effective, and focused. To further streamline proceedings, timeframes are established for specific actions, such as the requirement for the respondent to submit its response to the request for arbitration within 30 days after the commencement of arbitration. In cases where counterclaims are present, the claimant has 30 days after the appointment of the Asian Sports Tribunal to submit its defense to the counterclaim. Additionally, parties have 15 days from the submission of the response to jointly nominate the arbitrators. These measures collectively contribute to a highly efficient and organized arbitration process. Ensuring thoroughness and informed decision-making, the Asian Sports Arbitration Rules empower the tribunal to appoint independent experts. Now, these experts, after consultation with the parties, report in writing on issues designated by the tribunal. This provision allows for a deeper understanding of complex sports-related matters. Furthermore, the rules acknowledge the need for emergency measures, introducing the concept of an emergency arbitrator. Any party can apply for the appointment of an emergency arbitrator to grant urgent measures. The applicant party outlines the nature of the measures sought, the reasons for their urgency, and the legal basis of their entitlement to such measures. These provisions underscore the adaptability and responsiveness of the Asian Sports Arbitration Rules to the unique challenges that may arise in the sports domain. Diving a little deeper into the heart of the dispute resolution process, let's explore the Asian Sports Tribunal. As of today, this tribunal boasts a distinguished panel of 127 members, each possessing extensive experience and/or specialized training in sports arbitration. The diversity of this panel extends beyond regional boundaries, including individuals from the United States, the United Kingdom, and various parts of Europe. This global representation ensures that the Asian Sports Tribunal is equipped with a wealth of knowledge, perspectives, and insights into the intricacies of sports-related disputes. Parties referring their sports-related disputes to arbitration under the rules have a unique advantage. They can choose from the existing panel as their arbitrators, leveraging from the collective expertise of the seasoned professionals, or alternatively, parties can retain the freedom to nominate any arbitrator of their choice outside the existing panel. This flexibility is a testament to our commitment to providing a tailored and accessible dispute resolution platform. The Asian Sports Tribunal, confirmed or appointed by the director of the AIAC for a particular sports arbitration, stands as the guardian of expediency. It is mandated to conduct proceedings with a view to expediting the resolution of disputes, avoiding unnecessary delay and expenses. This proactive approach not only aligns with the overarching principles of the Asian Sports Arbitration Rules, but also underscores our commitment to delivering timely and efficient outcomes. Commencing an arbitration under the Asian Sports Arbitration Rules is as simple as the claimant filing the request for arbitration. This then initiates a chain of sequential steps from the respondent's response to the request for arbitration, the submission of any defense to counterclaim, the nomination or appointment of the Asian Sports Tribunal, and a case management meeting conducted by the tribunal. Finally, we arrive at the submissions and hearing stage, the culmination of the arbitration process. Appendix 2 of the Asian Sports Arbitration Rules provide a structured mechanism for the resolution of disputes related to sports selection and/or eligibility. Crucially, this service is available free of charge to the parties involved, emphasizing our commitment to accessibility and fairness. Parties retain the autonomy to seek representation or assistance at their own cost, ensuring a level playing field. In instances where disputes necessitate a more specialized approach, a special panel may be appointed. This panel is authorized to conduct its duties at the site where the dispute arises or any other place deemed appropriate. The special panel is obligated to provide a decision within 48 hours from the application for arbitration. This swift turnaround is indicative of our dedication to timely resolutions. The decisions of the special panel are not only enforceable immediately, but are also deemed final and binding upon the parties involved. This expeditious and conclusive process contributes to the efficiency and effectiveness of the sports rules. Arbitrating at the AIAC offers a multitude of advantages that sets us apart as a premier international arbitral institution. Our commitment to time and cost efficiency ensures that parties can navigate the dispute resolution process without undue financial burden or protracted timelines. The AIAC adopts a light touch administrative approach, recognizing the importance of a nimble and responsive framework. Our multi-currency support reflects the global nature of sports and the diverse financial transactions associated with it. The AIAC houses a diverse legal team equipped with multilingual capabilities, facilitating clear communication and understanding across borders and cultures. With over 45 years of industry experience, we bring a wealth of knowledge and insights into the specific challenges posed by sports-related disputes. Our strategic geographical positioning serves as a gateway for parties involved in disputes spanning different regions. The state-of-the-art facilities at the AIAC provides for a conducive environment for hearings, meetings, and other arbitration-related activities. Moreover, our dedicated ADR library stands as a testament to our commitment to continuous learning and staying abreast of the latest developments in dispute resolution. Our commitment to excellence has not gone unnoticed. The Global Arbitration Review survey in 2022 has recognized the AIAC for having the most affordable hearing venue among international arbitration centers. This acknowledgement reflects our dedication to accessibility, ensuring that the course of proceedings does not hinder parties from seeking redress to arbitration. Additionally, the survey has recognized the AIAC for having the largest hearing capacity compared to other institutions. This recognition further highlights our infrastructure and capabilities in handling arbitration proceedings of varying scales and complexities. As we approach the conclusion of my presentation, I invite you to engage with us. Should you have any questions or require further information, please feel free to reach out to us at sports@aiac.world. Your inquiries and feedback are valuable to us as we continue to refine and enhance our services. In conclusion, the Asian Sports Arbitration Rules, as navigated through the AIAC's lens, represent a landmark in the world of sports dispute resolution. Beyond the framework of rules, we offer a dynamic, efficient, and globally recognized platform for resolving sports-related disputes. Our commitment to fairness, neutrality, and expertise underscores our role as leaders in sports arbitration. Thank you for your attention and participation. That's all from me.
Thank you, Sanjev. Before we proceed to the first session of our summit with the topic from the drawing board to the pitch, why don't we take a quick coffee break? Light refreshments are served at the pre-function area, which is right next to our auditorium. We will resume the session here at the auditorium at 11:15 a.m. See you all shortly.
Did I sound like I was actually I left. I'm showing support by leaving. Hey, I was sweating at the volume session. Literally. So big. I was like sweating. No, I wasn't there, but I was like sweating out of fear. And then like, but maybe this is good publicity. Everybody will write about it. Right. Sorry.
Welcome back. We request you to take your seats as we will commence our first session shortly. Distinguished guests, ladies and gentlemen, we are going to move to the first session of our event, from the drawing board to the pitch, leveraging institutional rules in sports-related disputes. I would like to call upon our moderator, Datuk Sundra Rajoo, and our esteemed speakers, Honorable Justice Dato Anand Punudurai, Ms. Mary B.L. Thompson, and Ms. Lin Tan to come up on stage.
Welcome back. Very good morning to all of you all. And we are the first session. I have a very distinguished panel from Hong Kong, Scotland. Maria, and then of course young Arif Anand, and then Lin from the Asian Football Association, Confederation. Is it? Sorry, I'm going to introduce each one of them because our topic today is going to be from the drawing board to the pitch, and how do you you leverage on institutional rules to resolve sports-related disputes. So I'm going to introduce the speakers one by one, and after that, we are going to have like a fireside chat. I'm going to ask questions, and then we will get the responses, and then after that, we will try to keep some time for a little bit of time for questions from the floor. So let me first introduce young Arif, Datuk Justice Anand Punudurai. I know Justice Anand Punudurai before he was elevated to the bench, and he was called to the Malaysian bar in 1991, and he started on his legal career with Shen, in their well-established industrial law department. His practice was predominantly in the field of employment law, industrial relations, and administrative law. And then he also served as the chairman of the Kuala Lumpur Bar from 2009 to 2011. Judge was actually appointed as Judicial Commissioner on the 28th of November 2019, later appointed High Court Judge on 27th April 2022. He was empaneled with us as an arbitrator for a long time. In fact, he is also empaneled. We have asked him, of course, he will turn us down because he was on the sports first course. In fact, that is why he's here. You know, Justice Anand is still a very diligent sportsman. You look at his frame, you know that he's very, very focused on sports. He runs, and every time I see him, he's playing some game. You know, so it's very apt that we get him. And then I think he also served as the secretary of the first ever ad hoc arbitration panel in 2017 SEA Games, which took place in Kuala Lumpur. So he has real experience. Then the next panelist is my old friend, Mary Thompson, who is a chartered arbitrator, and she's a member, associate member of St. Philip's Stone Chambers in London, Singapore. Oh, sorry. I'm 36 Stone. Oh yes, 30 North, and then associate member now at 36 Stone, London, and Singapore Pacific Chambers in Hong Kong, is it? And also London. Oh, yep. She started her career in London, and she was called as a barrister in 1983 and undertook pupillage in the chambers of GRA Darling QC, now St. Philip's Stone Chambers in the Middle Temple. Now Stone Chambers. And Mary moved to Hong Kong in 1992, continuing to practice as a solicitor for over 20 years. And for most parts in dispute resolution, a partner in both Hong Kong and international law firms. I know Mary has been involved in many, many arbitrations for many, many years. So HKIC, ICC, SIAC, SCMA, LMAA, and also CTEC and ad hoc arbitrations. She's also a mediator, and she has done many international commercial disputes in both international trade, insurance, and banking disputes. I know Mary also as the chair of the Chartered Institute of Arbitrators East Asia branch, which is the largest branch in the world at that time. So that's how we all really know each other. The next panelist is Ms. Lin Tan, Senior Legal Counsel for the Asian Football Confederation. Ms. Lin was called to the Bar of England and Wales in 2013 and is acting director of the acting director of the Malaysian Bar Advocates and Solicitors Disciplinary Board. She is currently a senior legal counsel with the Asian Sports Confederation, Football Federation, and has more than 10 years experience in disciplinary and governance issues. So we have a judge, we have an international arbitrator, and a person who has been involved in sports discipline. So it's quite complete, the panel. Let me start off with the first question. Sports-related disputes generally encompass a wide array of disputes, including contractual disagreements among and between athletes and clubs, doping cases, disciplinary actions, and disputes related to selection and eligibility for competition. Now, from your perspective, would you share in what ways sport-related disputes differ from conventional disputes? And do you see a need for distinguishing between the two? I will start off with the judge because seniority. And thank you, Judge.
Thank you, Dato. I think quite clearly there are differences between the two. I think if you go back to what actually really are sports-related disputes, generally they're defined as either anti-doping rule violations, disciplinary matters, selection eligibility, and maybe bullying, harassment, and discrimination. Those are your typical sort of sports-related disputes that are dealt with via arbitration or other methods of ADR. When you talk about conventional disputes, I think really more or less you're looking at the breach of contract sort of issues. Of course, now in terms of with esports, you may have other issues, trademark disputes, etc. I think there are not many cases that have come to court. I think I have not had one before me. I think one of the famous, I think Tan Sri, you remember when I was in the IOC legal committee, we had the Masuma, that whole case in court about the tiger stripes, the jersey, right? I believe now the badminton one, there's one pending as well. But by far and large, very few disputes that actually come to civil courts. There are those distinctions. If you see a need for distinguishing the two, I think hopefully with this now, I think you can take your contractual disputes to the sports. Of course, it has to be sports related as far as possible, not just any, but there are a lot of contractual disputes within the sports arena as well. So I really don't see, I think there's no need to distinguish the two. As long as there's some sports related element to it, it should come through the arbitration tribunal as we have.
Yes, I just want to do a follow-up. One of the problems with sports related disputes is actually the intense media coverage that comes up from something like very simple, that I'm not chosen or the wrong person is chosen to do this particular sport. So how will that be handled in between a conventional and arbitral?
I don't think that, I mean, now with this, I've seen in your current, your model, if there's an issue of eligibility, you can use the sports tribunal to get a decision within 2 days, right? So I think in that sense, going to your conventional curial courts not going to be very helpful. You know, you'll be lucky to get a case number within 2 days, right? So I think I certainly see when I went through the rules that you've drafted, or you've already been implemented, there clearly is very much progress in this. And I think if there is the issue of eligibility, at the moment, I suppose it's done internally. And I think a lot of associations deal with it internally. And I think that's what we don't want. We want to avoid sometimes, because there is a lot of issue of favoritism, whatever you want to call it, right? So hopefully with this tribunal, it's eliminated.
I think the other advantage would be also the confidentiality and privacy provisions. So the intensity of the publicity may actually go down. Can I direct again that same question to Lynn? What do you think if you take a response on that?
Okay, thanks. For eligibility issues that we have for football is very different. We don't usually go for arbitration. So if there is an issue of eligibility that's arising from a competition or for a match, we will look at the matter, we will gather the information, and we will do very thorough investigation. Then we will put them before the committee for deliberation. So we looked into it in a very different perspective. So it takes a bit of time. It cannot get resolved within 2 days. But of course, if let's say it's an ongoing competition and the eligibility of a certain player is in question, then we do have more express channel, but very thorough investigation will have to be done first. So it is unlikely to go for arbitration at that point, even during competitions. So we have a very different approach towards eligibility checks. And because this involves players from various parts of the world, not just the 47 countries of Asia, but also other parts of the world.
Right.
Right.
Thank you. Staying with you, is that the next form of disputes that we do expect to see is types of and different forms of discrimination in sports. So what do you think, Lynn, will be the legal provisions or guidelines or codes to protect against such discrimination?
You mean discrimination happening in sports?
Yes.
Yes. We recently have a case of discrimination, which was very serious, discriminating against Chinese Asian cultures and all that. So we do have very extensive, it went all the way to CAS, and a decision was made against the player for discrimination. So we have provisions in our disciplinary code to cover on disciplinary against ethnicity, nationality, colors, genders. So when it involves discriminatory matters, we will go through same thing. We will do very extensive research, and of course also the public views of such actions of a person, whether it is deemed to be discriminatory in general or as a whole.
Judge, you have any views about discrimination in sports?
I think no doubt it's quite widespread. I think right. It's not really checked. I think in this country we live with it. We've learned to live with it. We're discriminated. Tough. I think if there's some stronger there are a lot of safe sports code. There are loads of definition of what is discrimination. Of course, you got disability, race, religion, sex, sexual orientation. The last one may be a problem. I think it needs to have some way of enforcing it. I think discrimination is there. We need the associations to really come down hard in cases where but a lot of times it's a question of the person being discriminated against is not going to take it up. I think that's the problem. Our culture here, live with it. So I think that is a problem we'll have to overcome.
What do you all think? Is there a need to actually for all the associations and all the sports bodies to have express provisions codified? What do you all think of that? Should that be codified, or is there such express provisions codified at the present moment? I know in FIFA they have. In FIFA, because I was on the adjudicatory chamber, FIFA says no to racism. So it's quite interesting that FIFA has it. But what is the situation in other organizations or in other jurisdictions?
I think there are some sports associations who definitely have and who have current anti-discriminatory policies. I think in terms of having policies in place, they are. But I said it's a question of somebody raising it as an issue and then being dealt with objectively. That I think is a problem we have in our society at large, I think.
Right. Okay. I'll go to the next question. Is that we have mooted this independent Asian Sports Tribunal some time ago, and then do you think that I'm going to be direct? Do you think this initiative is going to work? That's all, because, at the end of it, it's all, we can come up with this structure, but I'm going to ask the panelists, to give their honest opinion whether it's going to work. And I'm going to start with Mary as a person from outside looking in. Do you think that this initiative will work? That's the first thing. And then how this initiative, the Asian Sports Tribunal. And then second is whether how we can promote the use of ADR in sports. Mary?
So your initiative, Asian Sports Tribunal, you're trying to cater for a particular sector. And it is a good thing because in terms of resolution of disputes, as opposed to going to the courts, right? Part of the attraction.
We are happy not coming to court. We want less work.
It saves the taxpayers money as well, okay? If you're not having to pay the judge. But it does mean that the parties concerned, if they resolve it by way of, okay, we call it alternative dispute resolution. It could be arbitration, it could be mediation, or other forms of alternative dispute resolution. The attraction of going away from the courts is that you can choose often your own neutral, your arbitrator or your mediator. When you go to a court, you can't say, oh, I want Judge Anand. Was in arbitration, for example, or mediation, you can. And you can choose someone with expertise in your area, like sports expertise in your area. So it's a good thing, I think, that you have this sports, something that's catering precisely for the sector, and to draw up your rules that caters for it, and to have your panel where you actually train them, firstly, that there is these pool of people who are interested in sports law or sports dispute, and if they don't know about arbitration, you train them in arbitration itself. And in mediation, you can also do that. But I don't think you're likely to find training in mediation, particularly for sports, at the moment at least, but certainly in arbitration. It could be
the Asian Sports Tribunal is actually a rights-based arrangement, which is arbitration. It's interesting that you brought up mediation, which is an interest-based arrangement where there's a neutral trying to facilitate a settlement. So how do you think mediation can come into sports disputes now that we have the Asian Sports Tribunal having a rights-based thing, and how can we introduce that?
Right. I'm not sure if everyone here is already familiar with mediation, because I still see sometimes in the news when they report arbitrator or mediator, and they use it interchangeably. It is very different processes. So mediation, with an arbitrator, you expect the arbitrator to make decisions like a judge does. It's really a private judge. With a mediator, you're not expecting the mediator to make a decision. The mediator is often just a third-party neutral that try to facilitate a settlement between the disputing parties. So in terms of people are mostly familiar with arbitration. I think it's quite well established. Maybe not so familiar with mediation so far, but I think it can work together. Both of them are really consensual based, and party autonomy is a very important principle in arbitration, meaning party has the right to choose who the arbitrator is, or what the format of the process should be. Likewise, in mediation, you get to choose who your mediator is, you're neutral, and what background, and you can also adjust often. It doesn't have to be in a court of law, for example. I have had a mediation where it involves, say, a North Korean party and a Singaporean party, and they couldn't fly to, say, Hong Kong because of visa issues. And we just had the mediation in Shanghai, where it was easier for the North Korean party. So it has that flexibility. Now, in sports, I was looking around. I mentioned it earlier to one of the other panelists, at the regulations and the rules currently existing, and it doesn't usually talk about mediation. They might have separate rules for mediation, okay, but it's not usually intertwined. You can have mediation, parties can go to mediation, agree to just go to mediation, or they can combine it, what we call met up, mediation and then arbitration, or it can be up, met up, and a combination of that. So there is flexibility there. I would just caution in terms of, okay, the ideal is what we called stepped or multi-tiered dispute resolution clause. If you're trying to maximize and make it cost effective and make it quicker, and because you can agree to, say, negotiate, and if it doesn't succeed, you go to arbitration or you go to litigation. But I have a word of caution. If you're using that, because I've looked around at some of the regulations and rules, just saying that parties should enter into friendly negotiation can be quite dangerous. It can result in satellite litigation, you know, because what is meant by friendly? What is meant by negotiation? Have you, someone just say to the other party, oh, come on, we can settle this ourselves. Let's just have coffee and that's it. Is that enough? Is that a condition precedent that you have to have negotiated? Can you then start the next process of going to arbitration? Because then if one party disagrees that the condition precedent has not been complied with, they may challenge the jurisdiction of the arbitrator, okay? Or they may go to court to try to stay the arbitration. So the drafting of such clauses is important. Just saying, when all other internal steps have been explored, then you can only now go to arbitration. Has those steps been?
It's interesting that you talk about multi-tiered dispute resolution clauses. The experienced judge in the court there has been some element of mediation before the litigation, and can we actually apply the same idea in sports by we starting to look at a mediation provision tied back to the Asian Sports Tribunal?
Right. Good question. But before that, can I just say, you asked whether this sports tribunal will work. Yeah. I think for that, you're well known to be a good administrator running a lab. I think you need to put on a very good salesman hat. All right, you got to sell it to all the sports associations. I think when I was on the committee of some of the sports associations, most sports associations have their own dispute mechanism within them. And let's call a spade, and nobody wants to, they want to keep it within themselves. By asking them to, I saw in your rules, very good, you've actually given a model clause for them to incorporate, right? To refer to the arbitration. I think some may resist it. They want to keep it within themselves. They want to retain control over any dispute. And by coming to this, they will of course be giving up some of it. So I think you really got to sell it to sports associations if you want it to really work.
But how do we sell it? I mean,
I suppose you can
Judge, you know, I agree that we have to sell it, but you know, how do we sell it when there's such entrenched interest in resolving? In fact, I think Tan Sri, we went through this cycle with the government when we said that we wanted to do this starting with the Asian Sports Tribunal taking over sports dispute in the Sports Development Act. So we already had an inkling of how it is handled. So, you know, of course, I think you recognize the problem, but how can we actually overcome
I
that?
suppose just like anything, when you're selling something, tell them what the con of the current practice is and the pro of coming there. I seen Sanjev Sharma in his presentation said, look, expediency, the qualified persons. I mean, you've seen some of these sports decisions, the persons hearing the dispute haven't got a clue what's going on, right? And then you still can go to court. And after that, you can still challenge that decision. But so you're back to square one. So I think it's a question of, I suppose, expediency and the relevant trained personnel would be able to. I said, I don't think everybody will jump on the wagon very quickly, but as a matter of time, once you get a few and they see the benefit of this tribunal, I'm hopeful. End of the day, how long it takes, I don't know. And sorry, on mediation, just to say on mediation, you know, in the rules of court, we have if you have a running down matter, that means an accident case, compulsory, you must go for mediation. Any other matter is for the judge's discretion whether to send them to mediation. So it's for us to decide what can be mediated or not. I think sometimes it's a bit how to be honest, selfish in the sense. I try and send all my matters to mediation as far as possible because one case mediated, one case less to hear. But in a mediation perspective, in an arbitration perspective, and for me, whether I hear 10 cases, 100 cases, one case a month, my salary is the same, my income is the same, which is not very much, right? Whereas an arbitrator, once he's appointed, I mean, I wouldn't really want the case to be mediated. You know, I'm being very honest here, right? So I'm not sure how well. I mean, if it's mediated before the very early stage, he just gets his initial fee. That's fine. But I don't think I really cannot see an arbitrator appointed, unless I'm proven wrong. I'm not sure, to be actively pushing it for mediation because at the end of the day, he's going to lose a brief, so to speak.
Judge, I think it has to be from the institution itself. So we may have to consider whether we want to include a mediation provision prior to arbitration.
So what we're trying to do is to do in the courts now, we're trying to look at certain aspects where we some US has it, a pre-action compulsory mediation. Right. Which means it's like almost before you go for divorce, you need to go for counseling, you need someone to certify. So you get a certificate saying, I tried to mediate, I cannot mediate, and therefore then only you can go to court. But there are issues, like in civil courts, you have cases of limitation. You're near the limitation period, I can't expect you to go for a mediation course and then you're limitation. So there are issues like not straightforward.
May I suggest what I've seen for some institutions, arbitral institutions, in terms of trying to promote or encourage mediation? Okay, one way is they have in their checklist, in their rules itself, institutional rules, under the checklist, it includes whether they have considered mediation. The parties have to answer the question. And then empowering the arbitrators to make costs order against a party who, even though they succeed in the arbitration, if they unreasonably refuse to consider mediation, okay? Although, you know, it can be quite powerful. You know, there's been litigation in England, for example, where a successful party did not recover their costs, even though they were successful because they didn't do that, you know, consider mediation. And therefore, some of the arbitral institutions actually now write it into their rules. And I think I've seen it in ICC, you know, their cost guidelines to arbitrators as well, that you can make cost order to penalize.
So, okay, Lynn, do you have any views on this?
Sure. So for arbitration, we actually have the member associations or clubs, when they sign up for a competition, they will sign to acknowledge that Court of Arbitration for Sports in Switzerland would be the place to settle all the disputes and not the local courts of the country. And so when all the revenues, all the possible disputes can be settled between the disciplinary committee and as well as the appeals committee. Once a decision has reached its final stage in the AFC, it will then go to CAS. So we do have a similar module in our agreements with all the member associations and the clubs, where if they have any disputes or problems arising from that, it will go for arbitration in a court of arbitration for sports.
Right. This is what we are interested in. So we need to persuade some institutions
Yes.
like the Asian Football Confederation to consider this panel. So the panel itself, looking at the composition of the arbitral tribunal, that the way we plan, 1 or 3, of course, one solution doesn't fit, one shoe doesn't fit all. What, in your view, would be an ideal panel composition? Because you have experience with CAS, how does the panel system works? Because we are also modeling our Asian Sports Tribunal
Yes.
in somewhat like the CAS.
Yes, it
Because as an alternative, one of the reasons why we did this is cost. You don't have to go to Switzerland
Yes.
to do this. I think I remember that the first time I heard about CAS, I think Tan Sri in 2010 was the Lawn Bowling Association. I think they went to CAS to resolve a dispute, and after that they said it was so expensive that they just don't want to do this again. So, what do you think that we can do to the composition of the tribunal itself to make it very attractive?
Yes, usually it's, there are 2 options to have the sole arbitrator or we have the 3 panel. And for your information, I think you might be aware that the AFC, if we have, it's all stipulated in our regulation that if we do have an arbitration hearing, it will be done in AIAC as the alternative. So, but it will be heard by the CAS panel. And yes, the panel of 3 will be very effective, which I see that your code currently reflects. And for cost-wise, so far we have had hearings online. CAS has gone onto an online mode, and that has saved us quite a lot. But we do appoint counsels who are in Switzerland to help us to settle all the paperwork as well. So in terms of cost for hearing, so far CAS has taken steps to ensure that alternative hearing areas such as the AIAC has been proven to be very helpful for us. So I think if you can take over and instead, that would mean very good for you.
I'm very interested in the panel composition itself. How many panels that you have seen have diversity in it, other than women? That means diversity
Women.
in terms of nationality. Other than, let's say, whites,
Usually it's white.
Usually it's whites.
Male, white, old, stale.
Is it still pale and male?
I have not in my career dealt with all the CAS cases seen a female arbitrator.
No female arbitrator.
None so far. I have done.
No non-white arbitrator, or is there any non-white arbitrator?
If you count all the Europeans, Americans, yes, they're all whites. No Africans, no Asians, no female. I do at least 50 cases already, at least in the recent years. I have not, very sadly, not seen.
Actually, can we, from your perspective,
Yes.
Understand why it is like that?
No, I think it's because the panels, the arbitrators that are appointed usually based on experience, and because these people were already in there for so long, and so they are the experienced people that we want, and so they tend to keep getting appointed. So it keeps revolving within the same few people. You will see the very common names of arbitrators always appearing. They are always the white, the men, and old.
May I offer some studies? Okay, firstly, they don't represent the demographics or socioeconomic backgrounds of the complainants concerned. Okay, and studies like McKinsey, you might have heard McKinsey studies, which is not so old, 2019, something like that, did a study of about 1,000 companies drawn from many countries. And they found that those boards of directors, which were diverse, actually performed better than homogeneous boards. Okay, so there are studies, not just one. There's also Tufts University study that shows that a diverse panel or tribunal will likely give you a better performance and result. And they're not the only one who do it. So therefore, I'm a big fan of diversity. Actually, I give a training on unconscious bias because each one have their own unconscious biases. And when you come and all of them have the same biases, it doesn't really help. So, some institutions now have written into their rules. For example, I should declare my interest. I'm on the board of the Scottish Arbitration Centre, and we're probably in 2022, the first institution that have actually written into our institutional rules that all parties, not just the arbitrators, not just the institutions. I know Sepani has done it for the appointing arbitral committee to consider inclusiveness and diversity. But in the Scottish Arbitration Centre rules, which was launched at ICA in Edinburgh in 2022, it says all parties, including their lawyers and the party itself, shall consider like the ERA pledge, equal representation in arbitration, the real pledge, which was about racial equality for arbitration lawyers. That it is that. But by writing into the rules itself, it means that if a party criticizes diversity, they can rely on the provision that both parties have agreed to adopt that set of rules, and therefore that there should be these considerations of diversity within the rules.
I think our initiative, let me try to explain why we did this. First thing is location. Asia. So you need to have like CAS, which is in Switzerland. We need to have a structure in Asia. So I think this is an attempt that we first did. Second is the real complaint is that we don't have people of knowledge, skill, and ability with experience. So again, you have to do training. That's what we have done. And then it's very interesting because we are in Asia. When we look, if you look at the empanelment, most of them, many of them are Asians, because the training, the people who attended the training and the course were all Asian. So I suppose this is one way of addressing it. We can't insist that CAS has Asian arbitrators. You can't, because they say that we have our own criteria of selection on how we empanel arbitrators. So it's a chicken and egg situation. So now we have actually solved one of the problems. The next step is to actually go and try to, as Judge put it, create awareness locally. But I think internationally also we have to create and the quality of the panels must be very good.
Look at the rules. There are provisions for domestic arbitration as well as international. So I suppose domestic, you're looking at locally first, all the local sports association, local contracts. But then of course the target will be within Asia.
Yes,
Philippines, Thailand, Singapore, whoever wants a specialized sports tribunal to also refer it here.
That is the plan. The plan is that when there is an international case, then the panel will be international in nature. So we have structured it like that. So I think we are trying to address that, because we have only not had the opportunity to do it. So I think but sports is crazy. You know, people are crazy about sports in Asia, and they're crazy about sports in Africa. And it's quite unique that we, the Asian African Alco Center, is now doing this. So I want to go on to the next topic. Is actually doping. Doping. One of the real issues that always comes out every now and then in sports, because given the competitive nature of sports, so competitive it is, that winning at all costs becomes really a goal, that there is actually cheating by using enhanced doping becomes an issue, and there's a significance. In fact, when we did the first training, first few training, I brought Richard McLaren from Canada, and if you remember Richard McLaren was the author of the report for WADA on and which resulted in the Russian Olympic Council. Many of the athletes were banned from of taking part in the Olympics. So we brought in. So I asked him about how doping comes in, and he was explaining to me. So how institutional rules which deal with doping, how do they actually intersect with the athlete? So how do you actually, let's say, for example, in football, Asian Football Federation, and based maybe in other experience, how is doping dealt with, doping violations?
Okay, I think for this I have prepared a slide for the participants, for those who are here. So can we have the slides on the screen, please? So doping is a very sensitive topic, but very important. And we have seen a rise in slides. We've seen a rise in the use of drugs in sports, more so recently. So the AFC works very closely with, oh, it's not showing on this screen. Is it? Oh, it's that side. Okay, all right, okay.
You can see here.
Okay, so yeah, I think I can see that as well. So AFC, FIFA, and WADA, we work very closely to ensure that our competitions are free from doping. And so we have various aspects that we look at. Is it even on?
Can you control from anywhere or somebody? Okay.
Is it working? Okay. I think it's not. I think he controlled it. Sorry.
She has prepared some slides because I think we need an overview of how doping is handled, and then after that, I think we will understand, because one of the important role of the Asian Sports Tribunal will be also to decide doping violations.
Very good. That's very good. That's actually very good, because if you can see that these are some of the general concepts that we have. So there are 4 components. I'll put up all the 4 components. So there are 4 components when we generally consider a doping matter. So the first one, we will have to establish whether it comes from a specified substance, a non-specified substance, or a substance of abuse. Substance of abuse are usually those that are used outside the context of sports, such as cocaine and heroin. Then after, this will be considered by WADA. This is already in the list. Every year, WADA will produce the list of substances, and then they will define whether it's specified, non-specified, or substance of abuse. Then we will look at the burden and standard of proof, whether it is comfortable satisfaction for the organization, such as the AFC, FIFA, or FIFA. But it's for the player, it's just on the balance of probabilities. Then after we consider all that, then they will be looking at no fault or negligence, or no significant fault or negligence. This is very extensively laid out in the anti-doping regulation, available from FIFA's anti-doping regulations and also the AFC anti-doping regulations. And after that, if let's say they fall into one of these categories, we will look at the degree of fault as well of the player, objectively and subjectively. So it's not just a very rigid sets of rules, but we looked into all areas of this matter. So if you look at the general concepts. Okay, so on this, if you see for specified substance, the starting point is a 2-year ban from sports, from all football activities for AFC, all football activities, not just in Asia, but worldwide. So the ban will be a worldwide ban. So if it's a specified substance, then it will start off with 2 years. And if you do it intentionally, it will be 4 years. For a non-specified substance, the start-off point will be 4 years. And if you don't have the intention, then it will drop to 2 years or even less. So, and if it's substance of abuse, then you will need to go for treatment programs, and then it will be reduced accordingly. So then we have the burden and standard of proof. As I've mentioned just now, for AFC and for player is different. The burden of AFC is to establish the anti-doping rule violation. So of course, the burden must be higher because it's against the players and players' livelihood. So it will be at comfortable satisfaction. But if for the player, all he needs to do is to rebut the presumption and to establish the facts of what has actually happened. And that will be done on the balance of probabilities, which is less than comfortable satisfaction. Sorry, I'm doing this like a class now.
No, it's important because I'm learning something.
Okay.
It's very important.
So how do we establish the source then? We will begin with the science. So of course, we will go through all the reports from the adverse analytical finding from the labs of the WADA accredited labs. So samples will be collected from the player during a competition or outside of a competition, depending on what stage they are going on. And then after that, we will get a report from this WADA accredited labs on the urine or blood samples and to say that there is an adverse analytical finding. That means some drugs were found in the urine or blood samples. And then we will then consider the totality of the evidence. So we will go through all the evidence. We will ask the player to provide an explanation that is provided for in the anti-doping regulation. We will give the player an opportunity to provide an explanation of what actually happens. Sometimes it's the medicine that's prescribed by the doctors. Sometimes it is something they take on a supplement for slimming, for performance enhancing. And then after that, after we consider all that, then we will go through common sense as well. So if someone who is looking like some broomstick is telling us that he's taking some substance to lose weight, then of course it doesn't make any sense at all. So, but there are people who try to do that to us, telling us that they take the wife's pills, after birth pills and stuff like that. So we were very shocked to know the things that athletes do, the extent that they go to in order to have that performance enhancing effect. Then of course we will look at the athlete's credibility as well. So if he is a young child who've just come out to play and or compared with people like Cristiano Ronaldo, who has been in the field for a long time, who would definitely know what he should and should not take, then that would be very different. So there are a lot of considerations that we will go through when we looked into a doping case. And this is very tedious process, but must be done very carefully to ensure that the game is free from drugs. I think I have some more slides. So I keep that for you later, or do we go through it? Okay.
Actually, the next one I want to ask is that, of course, establishing the evidence is through a doping lab. What is the level of facilities in Asia supporting doping labs? Because, you know, I know in Europe, it's very, very strong. It is also very strong in America. But in Asia, can you tell us? Because it seems like it's one of the very foundational things that you need to have. Huh?
Yes, we do have a lot of very good WADA accredited labs, but they're not in Southeast Asia. They are in Asia, but they're not in Southeast Asia, not in KL, and definitely. But we do have WADA accredited labs, which are very good. They follow very strict protocols and policies to ensure that every report that comes out of it is quality, and the level of standard of operations that they do is very different. So the reports that they prepare is very different from labs outside, which we have seen where players usually will challenge us using some dodgy labs that will not give us very extensive reports. But if you go through a WADA lab, they have very extensive LDP, the laboratory document package, which will tell you from A to Z, from the point of the receive all the way to storage, chain of custody, and all that included in the report.
Is there a specific need to have a WADA accredited lab in Southeast Asia? If
That
we
would be
want to
great.
actually,
That would be actually very good, because cost of sending it to a lab such as in Qatar or in India is quite expensive. And also to ensure that the urine or the blood sample gets there in time and in a safe condition. So if you have one in Southeast Asia itself, then of course that will expedite the process.
why has it not happened in Southeast Asia? I'm just curious. I mean, there's one in Bangkok.
I
but is
think
it
they
accredited?
may have lost their license recently. They have been suspended. Yeah, so WADA will go through the checks every couple of years or maybe more in order to see if what they're doing is correct. The slightest problem will get their license suspended for a meantime, and until they are ready to go back onto the WADA list. So getting a WADA certificate, WADA accreditation is extremely good.
Because I remember once Malaysia had a lab in Penang. If I understand that, in the USM, I believe. So the judge, please.
Yes, I think I'm a bit confused because I'm quite surprised we don't have any. And maybe WADA accredited, maybe they're asking too much because we hear criminal cases, right? We hang people based on these drug reports. Huh? Maybe. USM, yeah, it was USM. You mean tests for WADA accredited tests? WADA tests, is it? Okay, because I think
No, you have to have enough, dope tests. Whether it's whether it's given so by the associations or the government or whatever it is.
Right.
So we didn't have enough tests. There weren't enough incidences of abuse that they didn't have enough tests to test. So the important thing, I think, for a lab, if it was going to be established in Southeast Asia, they've got to ensure that they have enough, of a market. And I think it has to be more than just the country. It has to be, Malaysia, Singapore, Thailand, maybe, Southeast Asia, and then it may be worth it.
It's a bit of a chicken egg situation because you're not going to have enough tests. You don't have the lab, and you don't have the lab. You don't have tests.
Exactly.
But I think I said I'm a bit concerned because not concerned, I'm worried because I said we send people to the gallows or used to on account of drugs tests done by labs here. We're not talking about sending someone to the gallows, just making eligible. So I cannot see why it's so difficult to have at least one lab. Whether it's if not maybe here Singapore or Bangkok, or I'm not sure what the problem is. Bangkok, I really can't, because if that is going to be a problem, then insofar as anti-doping issues are concerned, disputes, I'm going to see that. I see that as a problem.
I'm just curious. Those labs that are WADA accredited, are they private entities or are they public entities, public supported entities? All of them are public supported. So in India, let's say, and let's say in Qatar. Some of them are private, isn't it?
It can be. It doesn't have to be public. It doesn't have to be government. It can be independent. There's for me. I mean, it's if the people that run labs, like Gribbles or the Path Lab, say in Malaysia, were to set up, because they have the expertise and the people, the equipment. Something, a specific, sports doping lab. I think they with the, because they are marketing, their marketing company, their commercial company, I think it could be a success. I think unfortunately, University of Science Malaysia is not necessarily a big, it's not a big center, and Malaysia, didn't have enough tests, and the internationally, no one sent it, from international.
Too law abiding.
Hardly.
So I think there is for an entrepreneur to do it.
I think while WADA's may be very stringent, I think an establishment like Gribbles or Pathlight would definitely would take it up. I would think so.
No, it suggests that there has to be a commercial viability on one hand versus a need to actually meet that standards and at the same time hold it. Of course, we know Gribbles and all these things, they do have certain standards, but there's now a suggestion doping is a very high standard where you establish that. So going on to the next part, who is we when you say in the Asian Football Federation, we? Is a committee or is it because I was just curious because
AFC
when I'm just trying to establish who makes that decision when you say it's the we, is it the association itself or is it a group of people or
Okay, so for AFC, we have a group of panel committee members, the disciplinary and ethics committee members. We have the appeals committee members who will decide on matters that are put before them. Of course, they will not be on the panel if there is any conflict like so. But other than that, there will be a panel of independent. They're not really. Okay, let's not go into the part of independence. They are appointed by the AFC as the disciplinary and ethics committee. Of course, they are not related to the country that we are hearing about on the case, but they do have experts and experience in doping matters, which they have done before.
It's interesting because as a judge put it, most associations would have an internal grievance arrangement.
Correct.
And also a disciplinary arrangement. Because I was on FIFA, there was a disciplinary arrangement.
Yes.
And then you had an investigative committee.
Correct.
Versus an adjudicatory committee.
Yes.
So they separate that. But it's also very interesting that we are now going to take the adjudicatory part outside once there is actually a dissatisfaction with that particular grievance procedure.
There's actually room for you to maneuver in here, in my honest opinion, is that because now FIFA and WADA has, so AFC has introduced this operational independence, and the body who is actually handling the investigation cannot be the body that is also involved in the part of decision. So that proven to be difficult for FIFA as well as for AFC. Because of course we are AFC staff, the committee members are actually not working in AFC, but they were appointed as the AFC disciplinary and ethics committee members. This almost got discussed in CAS very recently in one of the doping case that went to CAS, but we did not manage to finish the case in CAS because there was an outside settlement. So we managed to have an agreement out of CAS, and we resolved the matter before it was actually heard by panel of CAS, where this point would have been deliberated, and FIFA was also a bit in looking into that. This case was because they didn't have a body to be acting operationally independent. So I think if AIAC in one part would be able to play a role, that would be very ideal, because we cannot be asking one of our member associations to be dealing with our cases.
Yeah, it's interesting. One of the things that I realized, the secretariat of this committee is actually from the association itself. So I mean, when I was in FIFA, although they say that the secretariat is independent, but the secretariat is employed by FIFA.
That's correct.
so there's a tension. There's a tension. I think this is the tension you're talking about. I suppose this is what we are trying to feel on that part. Now, going back, that you all did a settlement to do the thing. To what extent, doping, where doping is concerned, we can talk first about doping. can doping be settled? Because it's almost like a crime.
Yes, yes, it's
So
very
I
important.
mean, we all know that criminal matters cannot be mediated, cannot be arbitrated. Also cannot be mediated. Because it's offense against the state. It's an offense that actually it is that cannot be settled between the parties. So both mediation and arbitration cannot criminal matters. So where doping is concerned, does settlement work?
Okay, settlement only comes into play in very, very limited situation. Okay, I need to get this on again. Oops.
Next one.
All right. So there are, in 2021, FIFA and WADA introduced settlement agreements for doping matters. This is new since 2021. And the AFC actually is the first confederation in the world that did the very first settlement agreement. And this was done in collaboration together with FIFA. And they have made it very clear that this would be under the case resolution agreement. If we look at the bottom bit, this must include the player admitting the anti-doping rule violation. So at any point during the case, when we receive the report of the adverse analytical finding, to the point when we are charging him, we are investigating, or we are asking him for an explanation, at any point before a case comes to a conclusion, he can admit that he has the anti-doping rule violation. So usually that's the case. In 10 out of 10, players usually admit that there was an anti-doping rule violation. But then the excuse comes later on. I took my wife's pill, I took some unknown coffee, I have some milk from somewhere. Then, of course, the AFC will propose a consequence. That means we want to ban him for 4 years or 2 years. We will put that into a letter to him, and the player will then consider whether they want to accept or not. Then they will come forward and request for Article 24.7, which is to go for a case resolution agreement. This is where it gets very interesting. It is as though we assume the duty of the Disciplinary and Ethics Committee's duty, but we are not. And the provision expressly provides that this matter, whatever that goes under the agreement, cannot be shared with the committee. It must not be reviewed by a hearing panel. It is only internal for AFC and WADA. So what happens here is when a player, this is the case that we had was on an eye drop matter. He was in the military service and the military doctor gave him an eye drop, and he did not declare it on his doping control form. So every player, before they give their urine, they will need to declare if they took supplements, vitamins, any drugs, any pills, anything at all, within 7 days, or at least whatever that he remembers. So he did not declare that he took the eye drop. Of course, it was just for his eye. He wouldn't have thought about it. And then, so his results came out positive for certain prohibited substance. And then when we go through the case, we send it to him, he admits, yes, there was a violation. And then when he go through whatever medication that he took, he realized that it was for an eye drop. And so when he comes to us at this point, in order to expedite the matter, for him to quickly be able, the moment when there is a case against you, you will be provisionally suspended. So the player will be provisionally suspended. He cannot play, he cannot participate, he cannot train, he cannot do anything, he cannot even participate in seminars or talks or anything like that that relates to football. So immediately his life stops. So in order for him to come back quickly into the game, he will usually suggest a case resolution agreement. And he will then present his evidence on a without prejudice basis. So he will provide us with all the documents and explain to us. And then we will then look into the evidence and then tell him how many months we are proposing. So if, for example, if we proposed for 12 months, and we will discuss with WADA first, if WADA agrees with how we come to that conclusion, and if WADA and AFC comes to the agreement that, okay, we go for 12 months, and then we send it to the player. If the player accepts, done, and the player cannot appeal, WADA will also not appeal the decision. So then the player gets off after he has served his period of ineligibility.
So it's a form of settlement.
Plea bargaining lah.
Plea bargaining. Plea bargaining. This is what I wanted to say. Judge, you want to explain what plea bargaining is so that they know, because in litigation, we don't have it in Malaysia. Do we have it? No, we have, because it's a representation.
Plea bargaining. I mean, referee can
it's
also
a representation.
plea bargain and basically it's admitting guilty to a crime with a almost, for those days you would have the sentence already agreed, and now it goes back to the judge will decide on the sentence lah. But there's still a bit of risk, but
there's a risk,
but there will be definitely reduced time lah because of
or they may even reduce the charge.
Sometimes.
Right.
I think then the interesting part comes is what happens if the player don't agree, or if AFC don't want to settle. So we have a case before this which involved a Polish player and a quite high profile from AFC, playing with the AFC. Now he's gone back to play in the UEFA. So we didn't agree to settle this matter. There was just too much complication, there too many evidence. It was very obvious he was doping, and he has come to us and tell us that yes, I took this and that for this and that purpose. So in the end, the AFC says no, and we also have to tell WADA why we have rejected a brief. We were looking into this together with FIFA, and after our deliberation, we have then informed WADA that we have decided not to go into a case agreement. So we have the rights to choose whether we want to go on to it or not. But then what happens to the evidence? We have to not put it into the file. So whatever they gave during the time of agreement to discuss, to negotiate, will not be disclosed to the committee. So, and that is how the committee will then get a very independent view of the case. And of course, the player can then choose not to admit to that and then say that, oh, I didn't take anything. Well, in fact, very fact that we know that he already has taken something.
So it's like without prejudice discussion.
Yes, without prejudice at all. Yeah.
Okay.
So
you can see the concepts are very, very similar. That is actually permeating through the scene. I'm very interested in another thing, is that we did not know about it. It's very, very quiet. I mean, it's done.
Very few
very
cases
quiet.
only.
Okay. And we are going to do the same thing in arbitration. To what extent? Because media interest, the public interest, they are all very interested in knowing what is happening. So to what extent do you think that it should be made public in the public interest? This kind of information that somebody is doping, and because you know why? When I saw the WADA report on Russia, it was very public. It was totally public. In fact, the entire system was maligned. The entire training system in Russia was maligned because of that. So, you know, that was made public. So I'm just trying to think, you know, when they do this resolution, whether it should be made public, and if it's going to be made public, when it should be made public, or it should not be made public. Can I have the panel one by one to think about that? Sure.
Sorry. So for the regulation actually provides very expressly, very detailed, about 3 pages of publications and whether it should go on publicly or not. So in order to protect the player's identity, when you are being investigated, we have not confirmed. So you remain innocent. Of course, you cannot go on to public and then destroy your good name. Your career will be gone, whether you are proven to be guilty or not later on. So definitely no publicity before the case is concluded. And this goes all the way to the stage of appeal. Once the appeal has concluded, only on a certain period amount of time, then the AFC or the organization can then choose to must publicly disclose. So there are certain decisions that must be publicly disclosed, which is provided for by the regulation. So very expressly, very detailed listed, and at what stage only that can be disclosed, and of course whether the player wants to disclose his name or not, and all that. So there are a lot of things that there are some parts that requires consent of the player, there are some parts that must be publicly disclosed, but it must of course wait for the matter to be concluded.
So, can I ask the other panel members, what is your views in arbitration itself? Because the per se requirement, even in our act, there is a confidentiality provision. But we know certain kinds of arbitration, like investment arbitration, it is made public. So, should sports arbitration, certain kinds of disputes, be eligible to be made public? What do you all think?
I think the first stop is the cornerstone of arbitration has always been confidentiality for longest time. I think we seem to be moving a bit from that. I think your Rule 38 provides that confidential information disclosed within the arbitration cannot be disclosed. That's right. That's confidential information. That will be so. We're looking at the whole aspect of parties. Even then it says award can only be made public with the consent of all parties. That's what it says. So I think I'm a firm believer for, maybe because of my all hearings are in public. I've got a camera and 2 cameras in my face, day in, day out. I don't even scratch my nose in court, But I think insofar as if you look at if once the disputes become a lot more contractual disputes and all that go to arbitration, I'm a firm believer of precedent, right? Because I think making it public, number one, will have precedent for following arbitrations or arbitrators to follow. So I would be, unless there are reasons to make it to retain confidentiality, for example, some sexual harassment or whistleblowers involved or something like that, then there may be elements. I think default should be public unless there are reasons to make it confidential, as opposed to confidential in the default and then public only otherwise. That's my personal view. Right?
It's a good, interesting view. But Mary?
Okay, I think it has to depend on the type of the problem that's being faced. You get a contractual dispute, I think it's fair that it should remain confidential, especially in an arbitration. Well, if you get doping, and in the sense, there is plea bargaining there involved, right? I can see it being worked out in the context of, say, a mediation, because an arbitration would not be appropriate, because an arbitration, the arbitrator or the tribunal has to make awards, judgments, right? But in the context of a mediation, there can be like a plea bargain, there can be a negotiation, okay? And then the outcome of it, for example, in doping, if there was, you've got the reputation, you've got the livelihood, the career of an athlete involved, which, it's far-reaching for that athlete concerned. So that if the outcome is that there shouldn't be any banning or any suspension, then, his career is safe and still secure. But if the outcome is the reverse and there is a public interest in ensuring that the public knows, then perhaps that can justify the publicity.
It's very interesting. You all know that CAS decisions are actually published but anonymized. Anonymized, so redacted decisions come out from CAS. So Judge, answering your question, but that is actually a final appeal tribunal, totally final. That it stops there. There's no more after that. Actually, we have 5 more minutes. I thank you so much for the panel. I'm going to retain the panel here and ask if you have any questions from the floor. Please go to the mic, identify yourself, and then ask your question. If you have any questions, please come.
Hello, good morning. Thank you, panel, for the discussion. My name is Man Wai. I was working in the Singapore Sports Council. Back in 2008, we launched the Sports ADR. And pertaining to Mary's point about whether up met or met up, we have intentionally incorporated both arbitration and mediation. And I was thinking about Chairman's question also, the question of whether this sports tribunal will work or not. We had the same question. And 15 years on, we are still in the wilderness for two reasons. The first one is up met or met up, or whether there's a mediation or not. Apparently, the difference in sports compared with the normal kind of disputes is that very often the issue is not about money. It's about selections. It's about various other things that is non-monetary. So it may go to mediation, and then cases will also end in the wilderness. Don't know what happened. And perhaps on mediation, you become a media kind of thing. Seldom go to arbitration, if at all. The second one, I think I was listening to Lynn's sharing about the FIFA. Now, in sports, right, the national federations, NSAs, derive their jurisdictions or reference from the international federations. And in the IF, their dispute resolution points to CAS, right? So if that's the case, then at the national federation levels and the NSA levels, they also point to their parent, right? So within the sports, the parentage, right, there is a complete pathway, right? So the question I was challenged is, where does sports ADR come into the picture, right? So in our case here, in this sports arbitration or sports tribunal here, so the question is, how do you come in the picture? Are you, or do you want to position yourself as a branch of CAS? Do you need coordination with CAS? Yeah, these are the questions I have. Thank you.
Can I answer that? Selection disputes, we have said kickstart nominal. Facilities will be free. We will actually assist, especially if it's a player. That basically is that we are going to subsidize the arrangement. Basically, one, you need facilities. We have full facilities. Second, you need the arbitral tribunal. We will actually discuss with the arbitral tribunal to make sure that they are actually giving basically maybe expenses only and do it as a service. So eventually it will pick up. So that's one. Two is that, of course, CAS has set up a pathway. It's like a system. So if Asia and Africa wants to come out of it, we have to set up our own structures and pathways. So that is the approach that I think at least we are taking. So you must give an alternative. And of course, the debate when we first drafted this thing is very interesting. When I first started this, everyone, I mean, when they came from outside, they said that the final appeal must be CAS. I said no. I said the final appeal is through the Arbitration Act. So because we are tying back to the Arbitration Act, and you can actually choose, because it's an arbitral process, you can choose the seat of arbitration. You can tie back to any of the arbitration acts around the world because it's the seat. So the concept is different. So the CAS, when it goes up, it's almost like a court system. So the pathway is different, Manwai. It's a different pathway. So we are actually challenging that. We are setting up a different pathway. We just have to work harder to promote it and then make sure that it is acceptable. And then we have to ensure that there is a credibility over the long term. So I think two things that have to be done. First, of course, we address the cost issue for certain kinds of arbitrations, disputes. Then second is that we do a different model totally, which is using the international arbitration regime, not a appellate process. So I think you can see we have done it in a different way.
The question was, are we a branch of CSS? And you are very strongly shaking your head. So are we then in competition of CS? in a way.
I know we compliment everybody.
Compliment.
Everybody is looking for to be in the center. But you see, everybody says that I have a center here, I have a center there, I have a center here. Everybody have their own acts and all these things. But when it really comes, let's say I'm arbitrating I'm sitting as an arbitrator. It depends on the parties. They may decide on a set of rules. I'm giving you all now an example, ICC. We decide on a set of rules, ICC rules. Just like here, then we say the seat will be in India. So the arbitration law of India will apply, but the rules will apply also. So we are doing it in a different way.
So really putting choice there. There is a choice. There are options, different options. But also, I think if you want to sell yourself, you need to show that you look at what may be the shortcomings of the caste system and improve upon it, and also bring value to the whole process.
So, any other question? Last question. Okay, Balbe, Dr. Balbe.
Good afternoon. This is actually a question on what was mentioned just now by AFC rep on doping and plea bargaining. It disturbs me a bit because, just to give you a background, Malaysia signed the International Convention on UNESCO's International Convention Against Doping in Sport in 2006, November. And this was after the cabinet had ratified this in August 2006. Then we had the sports ministry coming into play, and they formed an agency called the Anti-Doping Agency of Malaysia, which actually monitors and takes action against doping. Now, Adamas has got what we call a results management committee, which I am a member, and also a few of us are here. And we are given the task when there's a doping case to take it up and to decide on the action that has to be taken against an athlete who is either post competition or prior to competition. Now the rules are quite strict under WADA, specified a banned substance which is specified or non-specified. The terms and the rules and the sentencing is quite strict. There's no such thing as plea bargaining. Now with what we heard just now is football having plea bargaining. Don't you think you are undermining and going against WADA rules? Because this will give another chance to the footballer to continue doing what he's doing, because under what we go through, we only have got the results management committee and there's an appeal case, and that's it. It's either 4 years or 2 years or whatever, and that's it. I need some explanation on this. Thanks.
Thank you. It's very interesting to hear this because this is also very new. And when we saw this change come into force, which was recommended by WADA to FIFA and FIFA's regulations of amendment, prior to the launch of this regulation in 2021, we had a very lengthy, almost 2 years of discussions on this point. This is definitely a provision that is not to be abused. So when we have a settlement agreement, it is not, and the provisions in there expressly states that it is not for a hearing panel to be looking at the evidence. So it is not a way for us to abuse the system or giving them a shortcut for football. But this is a way where WADA sees that there is no need to go through. It's not that a decision that's made purely by AFC or FIFA alone. It has to get the consent of WADA. WADA has to approve the proposed consequence before being accepted by the player after analyzing all the evidence. So of course, the evidence at hand that we have during this without prejudice discussion must be submitted to WADA. WADA will then look at it before they actually approve the proposed consequence. So in some way, we are not having a free go at the regulations, but it is a way out for the very rigid process that we go through. A doping case easily takes 6 months to a year, done by the AFC, or some even goes longer than that if we go to CAS. So when we have this provision, it was very useful, and for the past 2 to 3 years that it has already come into force, only one case managed to go through the case management. Other than that, they will of course attempt asking us to go into case agreement, into resolution agreement, but it did not happen. For AFC, we take it very seriously. Doping is a very serious violation. And when the evidence come to us, it's not as easy and as straightforward as an eye drop, and the substance found is exactly the eye drop. The military actually supports that. There was also the team doctor's view, and of course, they were already written in to tell us before that there is this eye drop thing. It's just that it was not on his doping control form. So a lot of things was considered in totality, that there was room for a resolution, then yes, only upon that, and before we even actually give the decision to the player to be considered, it has already gone through WADA and FIFA. So they would have looked at the previous cases based on the precedence of such a matter, how many years or how many months were imposed. Only then we make the proposal to the player for him to choose to whether he accepts or not. So it is not an easy way out for the player. This is still being controlled very strictly and rigidly. And if at any point during the discussion of this without prejudice discussion, we find that evidence have then become more prevailing and that it doesn't support his case, immediately the discussion ends and it goes back to the normal case.
Can I suggest, Dr. Balbir, what you're talking about is jurisdiction. You're talking about, you're asking that we have a national, state arrangement which is binding on certain people, which must be actually Malaysians, isn't it? I'm assuming it's only Malaysians. So whereas I think in the case of these federations and associations and all these things, it is the relationship with the association, the contractual relationship, the membership and all these things. So I think there is actually a distinct difference, but I'm of course, there could be double jeopardy, but if he's a Malaysian and he's also the sixth, so I don't know whether that will happen.
No, immediately when they participate in AFC competition, they are bound by the AFC rules.
So it doesn't really matter.
No.
Okay. So I think we have to stop here. I'm so sorry about this. We can continue. We can discuss with the panel members what you like to have. Can we actually thank the panel members for such a wonderful session? Thank you so much.
Thank you to our panel of speakers and moderator for that insightful session. May I kindly request the speakers to come below and stand in front of the stage. We would like to invite His Royal Highness Tunku Imran to present the token of appreciation to our speakers. Thank you, Your Royal Highness. With that, ladies and gentlemen, we have come to the end of our first session. Without further ado, I invite you all to join us for lunch. A sumptuous spread awaits you at the dining area located on the lower ground floor. There will be ushers to guide you there. As a gentle reminder, we will have our second session at 2 p.m. later. Our team will reach out to you and we would be delighted to have you join us for the session after lunch. Enjoy your lunch and we will see you at 2 p.m. Thank you. Welcome back, distinguished guests, ladies and gentlemen. We hope that you've enjoyed your lunch. We are now going to move to the second session of our event titled Game of Strategies, the Legal Frontiers of Technology in Sports. I would like to call upon our moderator, Ms. Leslie Lim, along with our speakers for the session, Mr. Lokok Keng, Mr. Yudhishthira Adipratama, and Mr. Abdul Rahman Garub. On stage to begin the session, please.
All right, good afternoon, ladies and gentlemen. Esteemed participants and distinguished guests, my name is Leslie Lim. I'm a partner from the law firm of Mawing Kwai and Associates, where I head the sports law department. I'm also the secretary of the Sports Law Association of Malaysia, SLAM, the co-organizer for today's summit. Allow me to start today's session by introducing our three speakers, and they all come from different countries. And so to start off, I'd like to start with our guest who traveled the furthest to be with us today, all the way from Saudi Arabia. But if you look at the brochure and the list of speakers, it would have stated that Mr. Majid Garub is supposed to be here with us today, but unfortunately he has an emergency to attend to. But fear not, he has sent his partner in his stead. We have here with us today Mr. Abdul Rahman Majid Garub from the law firm of Garub and Associates. His areas of practice focuses on media, entertainment, and sport sectors. He also advises on legal aspects related to financing, development, exploiting various intellectual property assets, and transactional matters. He also advises on software developers, SMEs, governmental and private institutions in culture, entertainment, and art. Welcome, Abdul Rahman. Yeah. Secondly, over here on my right, from Indonesia, as you can see, I'm coming closer to Malaysia. We have Mr. Yudhishthira Adipratama. He's the managing partner of Case Law Office. This is the first esports dedicated law firm in Indonesia. He's known for his expertise in the entertainment, esports, and lifestyle industries. He's also a certified capital market lawyer. He leads the legal front in Indonesia's dynamic esports scene, which I'm hoping we'll hear more about today. And he serves as the head of law and legislation for both the Indonesian Esports Federation and the Indonesian Video Game Association. And on the international front, Yudhis acts as an ambassador for the Australian Indonesia Business Council. Welcome, Yudhis. Last but not least, I'm sure you can see on the screen over here behind me, we have Mr. Lau Kok Keng, who's actually in Singapore, but he'll be joining us virtually today. Kok Keng, just a quick test if you can hear us loud and clear.
Yes, Leslie, I can hear you.
Great, thank you, Kok Keng. Kok Keng is the partner and head of the Intellectual Property, Sports and Gaming Department at Raja & Tan, Singapore. He has worked in various domestic and international sports governing bodies and federations. He's worked with football clubs, sports agency, commercial rights holders, sponsors, television broadcasters, cable operators, sports associations, sports bookmakers, and sports and media personalities. He's worked on issues which arise from the hosting of ASEAN Para Games, the SEA Games, the Asian Youth Games, and even the 2008 Beijing Olympic Games. I hope you don't mind, Kok Keng. I know you have a very long list of notable cases and transactions I saw on your website, but if you don't mind, I'll just pull out one, which is that Kok Keng recently assisted FIFA in brand protection and IP enforcement against ambush marketing activities in relation to the 2022 Qatar Men's World Cup and the recent 2023 Australia and New Zealand Women's World Cup. And among others, Kok Keng also serves as a member of the Safe Sport Commission in Singapore and the Institutional Review Board of the Singapore Sports Institute. Welcome to our three speakers for today. Can we give them a hand, please? Thank you for rejoining us. I hope everyone had a good lunch. To those who are joining us virtually as well, a very good afternoon from Kuala Lumpur, Malaysia. Now, our topic for this session is Game of Strategies, the Legal Frontiers of Technology in Sports. And the plan is very much for this to be an interactive panel discussion. I've had a chance to have some chats with both the two speakers here. Kok Keng, I wish very much you were here with us today. I'm sure we have a great chat and laugh. And if you don't mind, I'd like to kickstart the discussion by exploring that intersection between sports and technology. And I'm sure you will agree with me that that intersection not only brings about opportunities, but it also brings about challenges. So if you don't mind, Kok Keng, I'll pose the first question to you. Can you start by sharing with us what are some of the technological advancements which have had an impact on the sporting world? Can we start with that?
Sure, Leslie. Selamat petang, Malaysia. It's great to be able to join you in this summit, if only remotely. But I first want to preface my comments and response to Leslie's question by thanking the AIAC and the SLAM for inviting me to speak on this panel. Now, the intersection between technology and sport is something which has occupied my most recent writing endeavors because of the sheer developments that have been taking place, and because, you know, as I probe into how technology has impacted upon sport, I found more and more anecdotes, incidents, cases which have really piqued my interest. And perhaps, you know, I can share some of my thoughts with you today. I think technology has affected all industries in the world. Sport is no exception. And the evolutions in technology have enabled several aspects of sport to change, you know, mostly for the better. But, you know, as I will deal with later on, you know, sometimes there are some negative aspects of technology as well. It's affected the way sport is played, the way our athletes train, the way sporting contests are officiated, and the way spectators get to access sports content. Now, I want to give you maybe about 5 to 6 examples of technological advancements that have had a major impact on sports. And these are the broad categories that I can think of. The first is in relation to performance analysis and coaching. Now, so we had decades ago, the very first video camera that was, you know, placed at the finish line of athletic events. That is to capture photo finishes in the case of finishes that cannot be distinguished by the human eye. And now video camera technology has evolved into miniature cameras that are placed on, say, race cars, race helmets, goal posts, and even on the bodies of the athletes themselves. And these are typically used together with video analysis software. And today, such software has moved to the level where they are powered by artificial intelligence, you know, virtual reality and augmented reality. Now, the second category of technological developments that have impacted sports is technology relating to data gathering. And I think we will talk a bit about data later on, but just to give you some examples of how data gathering technology has been brought into sport. There is the Eastern Power sensor that is used on softball and baseball bats to track swing movements. Similar technology is used in the golf sensors called ZEP2. Tennis rackets have also been now equipped with sensors in the handles of the racket to track motion and speed. And, you know, even the players have had to wear sensors while they play the sport. So one instance is the English rugby team, the professional rugby team called Bradford Bulls, I believe. Now they made their players wear jerseys with sensors placed within the jerseys to track the players' heart rate, field positions, fatigue, and injury. So when the heartbeat of the player suggests that this person has really exhausted all physical powers, that is where they start to replace the player. The third category is about training. It's very much related to data gathering. But when you talk about training equipment, now you talk about wearable technology. So like what I've just said about the Bradford Bulls players, wearable technology can monitor your bodily functions, your temperature, your heart rate, hydration levels, and even brain activity. And these can then be used to create personalized training routines. And there are also sparring robots that are used. I've seen sparring robots being used for table tennis training. There's active virtual sports. So in July last year, Singapore hosted the Olympic Esports Week. And there were a few sports like taekwondo and motor racing that were actually used by real life athletes for training purposes. Many of these training stints, they involve the use of VR headsets. And I know some rugby teams, they use VR headsets to create simulated scenarios, such as line outs, attacks, high balls. That's, to improve the players' visualization of the game. Then fourthly, there's technology relating to officiating. And I'll talk a bit more about this, but essentially, we all know about VAR. A lot of you who are football fans, you have followed the highs and lows, mostly lows of VAR. They allow the match referee to have a second look at decisions involving potential awards of penalties, red card offenses, and offside. There's also hawk eye technology that is used in tennis to see whether or not the ball has gone out of the court. And there's goal line technology, somewhat a little bit older than VAR, but nonetheless, still fairly recent. Goal line technology in football is supposed to help eliminate human error or situations where it's just impossible for the linesman or the referee to determine whether or not the ball has crossed the line. Then fifthly, there is safety-related technological developments, right? So NFL, the American football, you know how violent it is. So players, they wear helmets. Now the helmets are smart helmets. They are equipped with sensors. They are equipped with magnet technology that are able to detect and dispense force. So there are often, hit collisions. So, when something like that takes place, the helmets are equipped to dispense the force across the entire helmet and at the same time communicate to the coach on the sidelines the extent of the force that has been caused to the player's head. So the precautionary steps can then be taken by the bench. And then lastly, there is performance enhancing equipment. I don't know whether you have heard of the Nike Vaporfly. It's a fairly popular running shoes that is available now in a commercial form. But when it was first produced, it was produced for the former world record holder in the men's marathon. It's a Kenyan athlete. His name is Elliot Kipchoge, if I pronounce it correctly. Now, he wore these shoes to complete an unofficial marathon in 2019 in under 2 hours. Now, the world record today, the world record stands at 2 hours and 35 seconds. It's held by somebody else who beat Elliot Kipchoge by 34 seconds. But Elliot Kipchoge remains the only man on earth to have gone under 2 hours in a marathon. However, that time is not officially recognized because it's not an official race. And there were also certain advantages enjoyed by him. Like, for example, there were people giving out water on bicycles, and there were people who set the pace for him. But he did it under 2 hours, and he wore that version of the Nike Vaporfly, which was then immediately banned by World Athletics because they thought that no human could ever go below 2 hours, and he did it. And World Athletics came up with this story that after they examined the shoes, they found that the shoes increased running efficiency by 4% by giving it some spring effect. I don't know how they came up with the 4%, but they said, well, this is the reason why they banned the shoes. And Nike then went back to the lab. They produced another version, which didn't allow anybody to run below 2 hours in the marathon. And that version was then approved by World Athletics. But this time they said that the reason why they approved it is that the sole of that new version acted as a lever rather than as a spring. And it merely altered the way in which the athlete's foot was positioned as the athlete ran. So, I mean, we can discuss more about, some of these matters that, some of which have actually given rise to disputes that are settled in courts. But, this is a snapshot of, the sort of technology we are seeing today in sports that have had a major impact on sports.
Thank you, Koking. I think the categories that you have laid out clearly show how technology in sports have given this positive impact in terms of athlete performance, officiating, as well as the protective or protection aspect. You were mentioning about safety just now as well. And I'm sure that with this positive comes challenges and disputes as well, because at the end of the day, everyone, wants to be the winner. They might want to challenge the way the results were obtained. And I'm very certain that there are different controversies and disputes that arise from those various categories. If I could get you to share maybe one example, and the other two speakers, if you have any to share from your respective countries, I invite you to do so after this. Koking, maybe one example? Yeah.
Right. Okay. So those controversies and disputes that have arisen, they are basically caused by either the use of the technology or the misuse of the technology or the failure of the technology, right? So I'll give an example of use of the technology that has actually given rise to disputes. And I want to cite the case of actually, well, I mean, it's probably something that most people already know, the case of the Blade Runner. And this is the South African athlete called Oscar Pistorius. He went to jail for shooting dead his girlfriend. I think he's already out on parole, I believe. But now he was born, without legs, or he had to amputate his legs. And long story short is that without legs, he had spring-loaded blades fitted onto his lower limbs. And he then wanted to participate in not just the Paralympics, but he wanted to participate in the normal non-disabled Olympics. And the 2008 Beijing Olympics was what he was gunning for. So I think at that time, he already had beaten, almost every other runner in the Paralympic world. So he wanted to move up the ladder. But then the IAAF, which is the former name of the World Athletics, they prohibited him from competing on the basis that his artificial blades afforded him an unfair advantage over able-bodied athletes. And Of course, he didn't like that decision. He sued them. He brought them to the Court of Arbitration for Sport. CAS allowed his appeal and cleared the way for him to participate in the normal Olympics. But unfortunately, for all his efforts, he was not selected by South Africa to make it for the 2008 Olympics, although eventually for 2012, he managed to qualify and he in fact reached the semi-finals, meaning he beat many other able-bodied athletes using his technology, which is the blades.
Thank you, Koking. Do either of you have any case studies that you can share on this point?
Well, the examples I have is for the challenges you're talking about, like where does this technology fall within? So I totally agree with the challenges my colleagues have introduced, but there are far more other challenges, which is the ownership of those data, those information, like the misuse. How do I use the information I've collected from my player to ensure proper training, to ensure success of my club, to ensure a lot of things. So there's a quite nice example from the MLB and NBA standards. Like the biggest issues is that who owns what? Does the technology company owns those information, or does the player owns the information that he received himself, or any of those items? So what they did is that they focused on the ownership of the data rather than they focused on ensuring that the athlete access to data is more important, because in the past when clubs had full ownership of everything, so they did not give anything to players, and that what caused the challenges with all the information. And you find players coming out saying that, oh, I don't know how to do this or to do that, and the club only is capable of providing these information. So their strategy is to allow them accessibility. So lawyers, most probably, or sports lawyers, are into extreme specific details. So when we draft a contract or draft something that we wanted to do that is related to technology, we have to be extremely specific. So you're going to use, let's say, with body cam. What is this body cam used for? Is it for media rights? Because if it's for media rights, then we're allowed to give it to TV shows to use it. How if it's not stated at the early stages, then why do I find my image on the TV? It's like you have to tell me that from the early beginning. So these are also one of the challenges, and this is an example of an entity trying to resolve a problem. So the MBL and MBA. So if you're going to use my data, you need to tell me first, where are you going to use it? So this is kind of an example.
Yeah. Yes. Yeah. Yeah, there you go. So I think if that question is directed to me, I will enrich the perspective from a totally different dimension, which in case it's not just a technology that is using the advancement of the sports that is using the advancement of technology, but I'm going to discuss the problem that exists within the esports itself. So the intricate web issues related to this kind of problem, disputes related to the gaining unfair advantages have become a focal point. Especially for this case, we can delve into three main particular problems. For example, like the e-doping, bug exploits, and also unsportsmanlike conduct. So speaking about the e-doping, e-doping actually is an emerging term from the doping, like in a conventional or conventional doping in a conventional sports.
if we talk about the definition of e-doping, doping is coming from the WADA, which issued the WADA code, and the definition would be the use of prohibited essence or method within a competitive milieu. So e-doping refers to the use of prohibited technology within a competitive environment. And speaking about e-doping, actually, I would like to exemplify, but I think I need more human interaction for this session. I just want to know, how many gamers do we have in this room? Do we have gamers in this room? What kind of game do you guys play? Like console game? What do you play, sir? Counter-Strike. I'm going to give another example regarding to that. Anybody plays a console game here? Console game? It's really hard to find a console player right now. Speaking about console game, it reminds me of my childhood back in several years ago. I was born 33 years ago, and I'm very familiar with, Crash Team Racing, if you know, Tekken, and also Street Fighter, for example.
I can guess your age now.
Yeah, I can pray. So when we talk about this as an example, when I was a kid, I love to win. And we have something when we play Street Fighter or Tekken, we have something we call as Game Shark. Do you guys remember about this? Game Shark. So Game Shark is one particular CD that provides certain code. It will enhance the power of our heroes. After that, one combo will be considered like 5 combos. And that's another meaning of e-doping. So after acknowledge this kind of situation, I just realized that I think I've been abusing myself with e-doping the whole time.
Admission.
Yeah, because as a kid, I just like to win. So in a more professional scene, I can exemplify. There was one particular competition for CSGO gaming, because you said that you play CSGO. I'm going to provide example for that game. The Extreme Line Asia Finals 2018. There was one particular player from the Epic Gaming, if not mistaken about the name of the club. This one particular player, they use one particular system called as aimbot. Aimbot allows you to see through the walls. So it's going to be easier for him to predict which direction the opponent is going to move, and that it's going to be, they are going to get killed easily. And another example for e-doping in traditional sports that is using the advancement of technology can be found with Hans Neyman, is a player of American Grandmaster for chess. He was, received serious accusation of using certain engine to help him in calculating his next move. And that's a serious. So this is a serious accusation. How are we going to combat this kind of e-doping? Of course, it's going to be like, there are 2 approaches I can actually share about it, and you guys can also share about this. First of all, we need to, the community needs to develop like a robust monitoring and detecting system, so that we can find that kind of conduct. If we find something that is not okay within the game, then we can share about this, and then we can raise reservation for, hey, this is not okay. The referee has to do something with it. And another one would be, this kind of awareness program, education should be continuous. So thank you so much for AIAC for gathering us like this, so that we can share this kind of knowledge, and it's very important for us to understand the situation before handling the situation. So another problem would be the bug exploits, and I would like to share my personal experience regarding to this. Anyway, bug exploits by definition is practically something, the strategic manipulation of programming errors. That's my definition related to the bug exploits. And this kind of exploits can range from exploiting glitching within the game to the attaining certain ability or certain power within the game. So, for example, this is my very own experience in SEA Games 2023 for esports number. The name of the game is Valorant. I represent my country, the parents' organization of esports, because esports is already considered as a competitive sport back in Indonesia. It's competed in multi-event. It was at the final round, Indonesia versus Singapore. So
Thankfully, Cooking is not here.
so he's going to defend. So in that round, the Indonesian player found that the Singaporean player used one particular hero. The name of the hero is Cypher. The name, this Cypher hero has the ability to place camera at certain location. However, the bug happens, and Cypher, because of this bug, happens to be, they have he has the ability to place the camera at will, resulting in the Singaporean player has a shared view with the Indonesian player, and that's crazy. And at that time, we submit an appeal, but unfortunately, our appeal at that time received no disciplinary actions. And I think instead, both of the players declared gold medalists. So you can just Googling the case, like this is where two players from two different countries, they received the gold medals. And I think this kind of example shows the need, of regulatory approach in this kind of situation. Again, it's very important for us to understand this phenomenon so that we can avoid, some kind of unfair feelings within a competitive environment. And how are we going to combat these bug exploits? Number one, that is very important that I can learn from my own experience would be collaborative communication between the game publishers and the EO, even organizers, needs to be bridged, needs to be well developed, because sometimes the game publisher, they don't want to tell other people, they don't want to tell any party that their game has certain bugs, because, for certain reason. But sometimes within a competitive environment, this is something that needs to be communicated. And the second one would be understanding the technical handbook when our player is participating in this kind of event. Because when we talk about esports, we have to find the difference between the violation within the law and violation beyond the law. Violation beyond the law will have something to do with the positive law, but when we talk about the violation within the law, it has something to do with the technical handbook, and it has something to do with the rules issued by the game publishers itself. And last but not least, I'm going to discuss about the unsportsmanlike conduct with the involvement of technology. For example, for this case, we can just spot easily by focusing to the element of malice. In Indonesia, because esports is already considered as a competitive sport, equally just like any other sports such as football, basketballs, it makes the esports ecosystem in Indonesia growing. And a lot of competitions, a lot of tournaments happens in Indonesia. And because of that, of course, the problem will also followed by the growth as well. Another example of unsportsmanlike conduct would be, this is funny. For example, like in a game, sometimes in a game, because of the internet connection, a player within a game can ask reservation to do the pause in the game by raising their hand. However, the case that I experienced myself at that time, I also act as the jury. There is one particular player, for example, like I am the player, and my friend here is my enemy, and our moderator here, Leslie, is my friend. So I know that I'm being aimed from behind by him. And then I asked the pause, and then I asked Leslie, you know what? I'm about to get killed by this guy. So after the pause is over, I want you to kill him so that I can save myself. That is, unsportsmanlike conduct that we can find in esports. And sometimes because the players are relatively young, they don't like being just like that. And they said like, hey brother, it's fine. No, you are not being strategic. Because there is a fair line between being strategic and being ridiculous. You're just being ridiculous. You can't do like that. And another example would be, the use of footages. In Indonesia, it actually happens in Indonesia for football game. And that's crazy. There was one certain party, they tried to manipulate the footages so that the referee outcome will be different. And I think that was some of the examples for the unsportsmanlike conduct related to the use of advancement of technology.
Thank you. I think you would agree with me that we have a very diverse panel before us. I think Kok Keng, with his vast experience, has shared the various different categories arising from disputes related to sports technology. Abdul Rahman has experience in the entertainment industry, which crosses over with sports. He himself is actually does motorsports racing, by the way. And clearly Yudis is very experienced in esports. But I'd like to pose the question back to our guests in the hall today. And those of you who are joining us virtually, please feel free to drop your comment in the box, comment box. So we've heard many different examples, and I want to ask this question. Do you think these disputes are attributable to one of these three? Is it because of the technology itself? Is it from the way humans are using the technology? Or is it a combination of both? Yeah, okay. So if you think that all these disputes are arising from the technology itself, could I get you to raise your hand? Oh, wow, interesting. Okay, who thinks it is as a result of the human's failure to use the technology well? Interesting, we see more hands. Who thinks it is a combination of both? All right, this is the most number of hands. Interesting, thank you, appreciate it. Now, so based on these examples that we've heard, we talk about the advantages, but clearly, as we said, human aspect is involved. And no matter how good the technology is, it always depends on the human that's using it. And many try to abuse it and use it for to gain an unfair advantage, which is going to impact the true essence of sports, which is always about clean sport and about fair play. And if I can open this question to the three speakers, and any one of you, feel free to take the questions. How do you think sports organizations, whether in Asia or globally, are addressing these issues of technology being used to gain an unfair advantage? Are sports organizations coming in to come up with certain frameworks, rules, etc.? Anyone wants to take this first? Kok Keng, if I could invite you.
Yeah, sure. Now, I think perhaps the best example I can give of a sports organization taking steps to level the playing field caused by, or which has been made uneven due to technology or access to technology, is the example of the very expensive Speedo LZR Racer full body swimsuit that was worn at the Beijing Olympics. That was the first time it was worn by swimmers. And that full body swimsuit, it cost about, at that time, $600. It could only be used for 10 times. After that, the efficacy of the material would be substantially diminished, and you might as well just throw it away or sell it on Carousel. But that swimsuit was touted to be able to reduce drag by more than 38%. And that enabled swimmers to swim at least 4% faster. Even if you are the least proficient swimmer, you can swim 4% faster. Okay. Now, so that swimsuit was used at Beijing Olympics, and amongst the swimmers who used it was Michael Phelps. And Michael Phelps set 8 world records. He won 8 gold medals in Beijing. He set world records. And not only did he set the world records, there were many others also who set world records using that suit. Or in total, there were about 43 world records that were set at the Beijing Olympics. Or rather, sorry, there were 43 world records that were set at the next major competition after Beijing Olympics, which was the 2009 FINA World Championships in Rome. So you can see that it made a mockery of human endeavor, pure human endeavor, because the swimmer was being made like torpedoes through the use of expensive technology. So what happened was in 2010, World Aquatics then decided to ban this high-tech swimsuit because only a select few countries could afford to have their swimmers equipped in that swimsuit. And the others who could not afford those swimsuits were placed at a severe disadvantage. So that's an example of an organization, a sports organization, taking steps to make sure that ultimately fair play is maintained and that technology should not be used in a way that would amount to unfair play.
Can I add to my colleagues?
Yes, please.
It's just that I think we just need to go a few steps backwards to really explain what does challenges mean when it comes to technologies. I would like to give an example of something that everyone here uses. So let's use WhatsApp. I guess WhatsApp is universally used by everyone. Am I agreed? Okay, so let me give you Saudi Arabia
Except China.
Except China. Okay, I'm so sorry about China. I think you guys have Line or okay, WeChat. Okay, so WhatsApp is not being used as evidence in Saudi Arabia in a very long time. So it's only been introduced 3 years ago because no one ever believed that WhatsApp used to be sufficient enough, even though it's technology. You know what I mean? So emails are universally known and accepted. However, WhatsApp took a long time for people to accept in Saudi Arabia as being part of evidence. So 3 years back, that technology was started to be accepted in court. Today, there's another conversation which says WhatsApp edits its messages. So does WhatsApp is now valuable as an as a source of information and evidence when it comes to legal evidence or any sorts of issues? So that's kind of issues we actually look at because things can be introduced as new technology. We use that technology. It turns out to be that there's a lot of improvements, things that lost its identity as the legality of the part of this situation. And these examples that they're providing is extremely advanced examples that shows that technologies are far more advanced than we ever thought. Like a suit could give you a boost of 30%. This is absolutely unbelievable. And that's why the problem with the regulators, the people who makes the law, are far behind. So we're still talking about accepting WhatsApp or not. And he's giving examples of suits that makes you swim faster. You get what I mean? So the laws are not there to protect us. We, our lawyers, are trying to interpret everything he's trying to say. So he's giving esports examples, which are extremely sophisticated. However, we're still haven't done any kind of laws for esports. These are all personal interpretations. And these are all personal efforts by law firms, by sport lawyers, by mega corporations to support these kind of things and try to explain it to the public. So it's not as easy as everyone thinks it is, like talking about technologies and finding solutions for them. The Saudi legal system, well, I'm giving Saudi as an example, is still confused to use WhatsApp or not. And he's talking about shoes that makes you go faster 4%. Like, do you know where we are and where the technology is and where the people are? There's a lot of people here might be extremely surprised about every aspect of technology that we might introduce. However, I'm telling you, there are no regulations for these technological advancements. Each and every entity does its own rules and regulations. So WhatsApp has its own rules and regulations. And if you look at WhatsApp rules and regulations, you see that it says, oh, you can't use me in court. You get what I mean? So it's completely different. So the technologies are constantly changing all the time and improving in ways that even when you do something great by introducing a kind of law or regulation, the exact same technology updated. It now can make you swim 50% faster, for example. You get what I mean? So, okay, so we allow advancement of technology by 40%, for example. So roughly, give and take. So there's a genius guy who made it 50%. How do we deal with him? Do we change the law? Do we add it to the law? Do we make an exception? Do we work on the sport itself to make it even fairer? And to be honest, there's a lot of solutions and there's a lot of things that we can actually talk about to reach out to a fairly safe way in order to have integrity in the games.
Thank you for sharing the legal framework or the room for growth in Saudi Arabia. And Yudis, if I could get you to share more of the landscape in the dispute resolution in the Indonesia side, and if you can add in if there are any trends, specific trends, maybe perhaps over the last couple of years, relating to that intersection between technology and sports. If you could specifically in Indonesia, it would be great. Thank you.
So alternative dispute resolution mechanism that has the nature of, the adaptive nature of alternative dispute resolution paves a way for ensuring a fair championship, especially the flexibility of to engage experts as arbitrators. So in this kind of particular case, I think like it will open certain avenue for us to get nuanced assessment from experts, because again, from we can see the development of this kind on and the acceptance of this kind of phenomenon is different in each country. And I think that alternative dispute resolution not only just adaptive with the development of technology, but also can leverage experts' insights in relation to solving the problems that is happening within the use of technology in traditional sports and also in esports. So another question would be, how about the trends in Indonesia? How Indonesia address this phenomenon? Back to Indonesia, esports is very, very big. And with that, in 2020, September 2020, the government makes esports as a competitive sport. And since then, it will be treated and it will be subject to the positive law in Indonesia. And it's because at that time, the positive law in Indonesia is not ready. The government moved. They do the amendment of the Indonesian sports law into the new one. And I was participated by joining the 10 commissioner. Practically at that time, I was invited to provide my insights related to this situation. And just sharing, I feel like a little bit goosebump, because at the time I put like 10 suggestions, and there was one particular suggestion in which the exact same word is written into the law. I thought they are going to just take, the main notion about my suggestion. They put every single word that I wrote for the suggestion. So that's pretty crazy. And it's because of that, back again to the phenomenon in Indonesia, the government, they are not just working with they find the intersection between several ministries in order to take the biggest benefit from esports phenomenon in Indonesia. Actually, it will be working under the Ministry of Sports and the Ministry of Sports and Youth. But another minister from the Creative Economy Minister, they also take the part in order to to make a bigger benefit for this country. We have something we call as esports tourism in Indonesia. What is esports tourism? So practically in Indonesia, if we are talking about data, we have around 5.2 million gamers in Indonesia. And it's because of the support of the government by making the internet access is everywhere in every provinces in Indonesia. We have that number, and it's already around 25% of the entire population. So can we imagine if we can bring like one championship and we allocate that championship in particular province, and people will go there, they will lift up the economy. That's what we call with the esports tourism. And I'm also helping the government in creating this kind of scheme, because when we talk about esports, we are no longer talking about the law under the level of the players itself. We are talking how are we going to boost the economy of this country. And speaking about that, how about the alternative dispute resolution? Back to our topic. The same law that introduced the acceptance of the technology within the sports also stipulates the terminology about the needs in particular, the need to create independent institution related to sports law. So this is the, this phenomenon is kind of shifting the trends, and I'm very happy because Indonesia is very adaptive with this kind of situation.
Thank you. I have a big picture question, which I would like all three speakers to answer. You can answer yes, no, and if you would like to give reasoning to why yes and why no, I appreciate if you could try to keep it in under 2 minutes, okay? So, because we've got a bit more to cover. And my question is, do you think there is a need, or would it help if we have a global oversight body when it comes to technology in sports to preserve that integrity in sports? So we spoke a lot today about doping and WADA, which is the World Anti-Doping Agency, and WADA serves as that global oversight body. And do you think we need one when it comes to sports technology? I see. Yes, let's go. Yes or no?
Yes, I totally agree with you. And you chose a perfect example, and I will give you another example. Is FIFA. You can see how properly football is regulated, and they are the organization that introduces the technology to the sport, and tells how the club and leagues and federation to how to use it. So the clarity of the laws are clear for everyone. Everyone knows how to do it. It's not merely anyone goes to any technological company and just introduce something new to them.
So a global integrity body would be able to work with the international federations side by side, hand in hand.
Absolutely.
All right. Yudis?
And my answer will be also yes.
Okay.
It's because, and I think actually one of the reasons why I want to participate in this event is because I know that the IOC people, one of the IOC people will come here, will attend, because this is a discussion that we have to bring. Because you know what, when we talk about the positive law, everything is written under issued by the IOC will be ratified and become the positive law. So we need this kind of, the global intersection and the global discussion to make everything becomes clear, to make everything becomes written. We need to be, meticulously understand this issue, because technology is not something that we can avoid, and we are moving forward for that.
Thank you. Cocking?
I agree that technology is not something we can avoid, and whatever we do, we must not be seen to be trying to stunt the growth of technology or the evolution of technology. I mean, technology is neutral. It's how we use it that makes it wrong or right. So my short answer is no, I don't think we should have an overarching body to deal with what you can call tech doping. But I think that the issue of tech doping ought to be dealt with by individual international federations, because no two sports are the same. You can't have one size fit all. It's not like, drug doping, where a drug is a drug, and, performance enhancement is performance enhancement, whatever sport you're in. But for technological or use of technology, I think each sport ought to be regulated differently. I think the key really is to have rules in place. I think Yudhishthira, you mentioned the SEA Games gold medal Valorant match, Singapore versus Indonesia. I was actually on the SEA Games arbitral panel. Unfortunately, because Singapore was involved, I wasn't supposed to be involved in the dispute resolution. But I mean, from what I've heard behind the scenes, I think we can even write a book on that whole saga. But ultimately, it's really about game publishers not really being into multi-sport competitions and not having covered everything that they should be covering by way of the game rules. And the event organizer, SEA Games Federation, can do nothing about it. There's no global, unified, centralized international federation for esports at the moment. And even if there is, to what extent can they set the rules? Because the game ought to be played in accordance with the publisher's rules and not the World Federation's rules, right? So I think that is the nut of the problem, not having enough rules or clear rules to deal with what amounts to impermissible use of technology.
Interesting. Thank you. Do you have something to add? Okay. Abdul Rahman wanted to say that he completely agrees with you, Koking.
Thank you.
Right. I'd like to shift gears a little bit because and move on more towards IP, because really at the heart of sports technology lies IP, which is intellectual property. And Koking, if I can invite you to share what are some IP that exist in sports technology, and I'll get Abdul Rahman to jump in on this topic as well. If you could also expand on that, examples of maybe disputes that have arisen in terms of IP in sports technology, that would be great as well, Koking. Thank you.
Okay, so when you talk about sports and IP, you can have IP in the way certain sporting moves are executed. Although that's probably going to be very difficult to have exclusive rights over it. One example I can think of is when somebody perfected the art of doing a somersault throw in football. So basically, to enable the ball to reach further, they hold the ball, they do a somersault, and then on their turn, the ball then flies. Nobody has ever thought of patenting it, although it's possibly patentable in some countries. But really, we are talking about protection of technology rather than the way certain sports are played. So in terms of technology, I think protection would probably be through patenting or reliance on copyright in the computer codes. Patent protection, well, it's slow, it's costly. You need to do it in every country around the world if you want to get protection there. So it's not feasible in the fields of industry where the pace of innovation is even faster than the process that needs to be undertaken to secure IP protection. And IP protection for patents, you take 3-4 years. Whereas innovations happen in 3-4 months. Copyright protection, it may not be the answer either if the innovation can be reverse engineered or it can be rebuilt using different software codes. So I think in practical terms, it's really about having first mover advantage that may be more important than the IP protection. In terms of disputes, patent disputes, well, there's one very recent case. Just 2 months ago, Nike sued New Balance and also Skechers for alleged infringement of Nike's patents for Flyknit. There's a technology that they created, which is used to make high-strength fiber material for shoes, to make the shoes lightweight, but at the same time offer a strong support. So Nike took basically about 10 years to develop this technology. New Balance used it in some of their footwear. So I have the names of the footwear: Fresh Foam X 1080 and Fuel Cell Supercom. So if you're wearing those shoes or you own some, then please hide them away because they are allegedly patent infringing. And Skechers shoes, I think their Ultra Flex models, some of their models also use this technology. Puma and Adidas also tried to use it. Nike sued them as well, but they have since settled the matter. Another pending case Nike has for use of this technology is against Lululemon, right? So for fans of Lululemon, please check the shoes that you are wearing. Just make sure that it's not the shoes that are the subject of the patent infringement case. Now, even more recently, I think just 2 days ago, I read in the papers just 2 days ago, Apple had its Apple Series Watch Series 9 and Ultra 2 restrained by the US Federal Circuit Court from being sold. And that's because that series, the later series, has got a technology that allows blood oxygen to be traced. And you get readings of your blood oxygen levels on the watch. So Apple has been told by the courts just 2 days ago not to continue selling those watches with the blood oxygen sensors. So again, if you have any of these Series 9 watches, please keep them away.
Thank you, Koking. Abdul Rahman, can I get you to jump in on this?
Thank you for the beautiful examples, to be honest. The thing about intellectual property is it's really difficult to explain because intellectual property is everything. I presume everyone here has a smartphone. Every smartphone here is patent. I know they're all the same to you guys, but it's completely different when it comes to software to different companies. And it's completely different. That water bottle could be patented. Everything you see is actually patent. If they had proper lawyers, that's what's the most important part of it. You can. I'm not joking. There is a lot of things that you cannot possibly imagine. It could be an intellectual property. Maybe the seats you're sitting in right now could be patent. Like there's a company said, "Oh, I make the best lecture seats in the entire world," and that's the patent for it. And this is the perfect example. So, what does intellectual property mean? So, let me give you an example. Of WIPO. So WIPO is the World Organization of Intellectual Property, and it has a definition actually for intellectual property, which says it refers to the creation of mind, such as inventions, literature, artistic work, design, symbols, names, and images used in commerce. So that definition sounds like everything. So anything to me could actually be patent, and especially when it comes to sports and technology, these are the most important factors that technology exist in as intellectual property, as patent, and what is meant to be used for. The most important factor as legals and legal frameworks and how to actually develop technology and intellectual property when it comes to sports is to actually state what is this technology being used for and how can clubs, teams, other people can use it. Because when we introduce let's say goal line technology, what is goal line technology used for? Just to check if the goal went in or not. So you can't use the technology for anything else. So I know the camera is stated perfectly to find another problem, but we're not going to use that camera for that specific purpose because this camera is meant for goal line or for scoring goals only. And this is, I think this is the best way to explain what is intellectual property. And when you want to mix intellectual property with sports, then to be honest, it's like everything. So the shoes, how to improve, how to go, how to move further. Like if Nike patented their shoes, and then so mega corporations sometimes uses it as monopoly because when they introduce something new, they don't want anyone else doing it. And when they don't want anyone else, like for example, like Adidas did the Ultra Boost to mimic Nike so they can follow the technology because everyone wants something new, something better, new products to sell, and that's how life works. And the thing is that I want to make something and I don't want anyone else to do it with me. It's a really mixture of intellectual property and monopoly and all these kind of stuff. However, we're looking into patents being time limited. You can't have something forever. So maybe Nike could introduce a shoes, new technology. They could do it for 5 years, 10 years alone, and then you'll find different companies coming in. And this is intellectual property.
Well, the rate technology is evolving will be less than 5 to 10 years, probably much faster than that.
It's literally an update. So even iPhones, every single software update is a completely new patent. Completely new patent. So it's like patent number 1.02, for example, if like the update is already 7.00215. You get what I mean?
Yeah. Yudis, earlier in the session, Abdul Rahman was saying about one way to address these issues related to technology and IP is to state clauses very clearly within an agreement. Do you agree that, or do you think that these agreements, whether it's related to athletes or associations or teams and players, do you think these agreements play a role in perhaps mitigating the disputes? Because if things are clearly stated within the four corners of the contract, that can perhaps prevent disputes from arising. What do you think about that?
I think the contract plays significant role in mitigating the dispute that will be arise in the future. But regarding to this situation, I would like to delve into two particular segments. Or the first one will be the intellectual property aspect, and the second one will be the personal data collection aspect. So for the intellectual property aspect, there are concerns in some of the clauses that needs to be clearly stipulated in the agreement between the player and the club. For example, like the image rights is very important because sometimes, for oftentimes, players transform into celebrity. And when we talk about image rights, it has to be, we need to declare like very, very clear about how many photo shoots will be taken during the contract, which platform they are going to use the picture, because it's not just about social media platform. If the picture transform into t-shirt, it will be something else as well. And another thing.
An example? Yeah.
Sure.
Does anybody knows Mohamed Salah in Liverpool? Do you know the famous case that happened with Mohamed Salah regarding image right? Okay, so basically he's a Liverpool player. Liverpool owns their image, and fortunately, Mohamed Salah is the main sponsor for Vodafone in Egypt before going to Liverpool. So one day they stuck his face on an airplane and this caused a massive problem for Liverpool because they were stating that Vodafone have used the personal image of my player to gain an advantage and make money. And basically they won the case and they removed Mohamed Salah's face from the airplane.
I can smell the lawsuit in there. So, and another, after we talk about the image rights, we can also talk about the broadcasting rights. Again, it's because sometimes well-established player will transform into celebrity, and as a celebrity, they will have their own management. So these broadcasting rights will have to do the revenue split. It has something to do with the agreement. Everything should be discussed at the very first time before joining with certain club. Another thing would be the allotment of the prize pool. So it plays significant role in motivating them in order to win certain championships. For example, like we need to make everything clear at the very beginning, whether 100% of the prize pool will go directly to the players or to the athletes, or only 20% or another scheme. And the last would be, about the advertisement clause. It has something to do with the, for example, like if they have their own management, the players in this case, sometimes the player is more well known compared to the club. And when the brand approach the player first, it has to be clear whether they are going to send it to the club. Is there any exclusivity clause between two of them? And then you also need to answer if will that be able to take the marketing fee if the brand approach the player first. This is something that we have to consider. And another thing, another sphere would be something discussing something related to the personal data protection. So I do believe that agreement is not only plays significant role as as a element to tell us our responsibility and our rights, but it can also play a role as an educating platform. It is very important to notify that the players, that the personal data of players will be used for certain things. For example, for the registration of the championship or for the sponsorship and etc. And another thing will be the legislation from another country. I would provide example. For example, like this. Indonesian club as the host country will transfer its player to different country. For example, like in Thailand. And the Indonesian personal data protection law requires that the host country will have at least equal or more comprehensive legal protection for accepting the certain information about that one particular player. And the problem is when one player will be transformed to Thailand, the Thailand club will submit or will register this player for the health insurance, and health insurance require medical record. Medical record in Indonesian perspective is under the classification of particular or specific data that falls under that law, the positive law in Indonesia. So it will, there will be the need of two lawyers from different countries to work together to do like a limited due diligence regarding to that transfer of data. I think that's it.
Okay, thank you. So you ended on the word that I wanted to pick out. The word that's been floating around for the last hour is the word data. And we can spend another hour just talking about data. But Koking, I really wanted you to weigh in on this. Because earlier you mentioned when we spoke about a global oversight body and you said we need clear rules. Now, when it comes to data, do you think the same applies, that if we have clear rules on the who, what, when, why, how, that will help in terms of the data aspect to govern its use and prevent abuse?
Well, on the issue of data, it's really not about having a centralized body dictate policies and enforce them. It's really on a territorial basis. So depending on where the data is collected and where the data is used, different laws of different countries may apply. And I don't think the sports industry ought to be treated any differently, because ultimately it's about collecting personal data, be it biometric data or data about how certain athletes are tracked, and performance projections, metrics, and so on. Now, I think maybe some useful guidance can be obtained from looking at how different sports bodies have their own rules on the collection and the use of data. So I'll just look at the US, and in the US, a country that calls football soccer, they've got four major sports: baseball, football as in American football, hockey as in ice hockey, and basketball. Now, so each of these sports, they are governed by different bodies. So MLB, Major League Baseball, they do have a collective bargaining agreement, I understand. And this agreement, because I think it's got shades of trade unions involved, they restrict the Major League Baseball and the affiliated clubs from selling data that they collect from players who use wearable technology that the baseball clubs require the players to do. And at the same time, they grant the players access to their own data that have been collected on them. The NFL, National Football League, their position is, I think, that each individual player owns their own personal data that are collected by sensors that they wear. And they allow their players to sell their own personal data to third parties, such as, say, TV networks and sport technology companies. So that data may be actually very useful because it could be used for sports betting and allowing certain predictions of outcomes to be made using that data. National Hockey League, I believe they do not prohibit collection or sale of the data of their athletes. They themselves have used technology to collect data on hockey players, data such as their skating speed, skating distance, the shots taken, and the speed at which the puck travels, when the shot is taken, and so on. And they have a very open policy. They actually publish these statistics online. And lastly, National Basketball Association, NBA, they too have a collective bargaining agreement with the NBA Player Association. And this prohibits the use of data collected on players who wear technology or devices that collect data. But they can't use it for player contract negotiation. So that's that's something that's very, very unusual. But it's really something that they have really thought through carefully, because the data that is collected on a player will also show the player's weaknesses, propensity to be injured, a bit like Thiago Alcantara of Liverpool, injured the whole season and get paid every week. So if he wears all these devices and then data about how weak his knees are, for example, is allowed to be collected and sold to people who may think about wanting to sign him. That's not allowed under the NBA rules. And the NBA only allows data to be collected for purposes of assessing the player's health and formulating team tactics and strategy, depending on how fit the player is, right? So you've got, different approaches by the different major sporting leagues in the US. And I don't think, you can have a single approach that is imposed on all sports and all sports organizations by an international body.
Thank you, Kokeng. I have under 10 minutes with the three of you, and I really like to wrap up with the last two questions, just bringing it back to sports ADR. Abdul Rahman, if I could pose the next question to you, and clearly with technology advancing, this is going to impact evidence that is presented at arbitration hearings, and the admission and also the reliability on those evidence as well. What do you think sports arbitration bodies can do in light of this? What steps do you think they can take? What do you think they should be looking out for, etc.? Over to you.
To be honest, when it comes to technology and data, especially when we're talking about alternative disputes, to be honest, I don't like the word dispute at all. It's like our main target should be to avoid disputes from the beginning, and this is what I've tried to explain at the early stages. Is where you have to specify everything, because every single example my colleagues have used, especially the NFL one. The NFL one he's absolutely right, where the players could have owned their own data and sell it for you, so it's purely commerce-wise. So the main objective is always to make money, and that's where people start to find those disputes. And when it comes to technology, it's fairly difficult to follow, especially for arbitrators, I would say so. So I think my recommendation for them is to actually have a look at what the technology is being used for, because they need to be extremely, I would say, transparent with the technology use, because everyone needs to know exactly what they're doing. Because the second there's unclarity between any of the parties, then that's where disputes happen. It's because the unclarity.
Kokeng, you have anything to add on this point before I pose the last question to you?
Sorry, can you repeat the question?
The question is, in light of technology evolving, this could potentially impact the admissibility and reliability on evidence. And is there anything that these sporting organizations or even the arbitral bodies can do to look out for or to overcome these challenges, so to speak? Yes.
Okay. Now, as you may know, rules of evidence don't apply strictly in arbitrations. So, insofar as sports arbitration is concerned, the tribunal has a much greater latitude to admit evidence. All they need to do is just accord the appropriate weight to the evidence. Evidence that is obtained with the technology, that's something that's still very new in some areas, because the way in which the evidence is obtained may turn out to be unreliable because of the processes used to obtain the information. So if you have evidence of doping, then the samples that have been collected may be compromised through certain processes that are used in the collection and in the storage of such evidence. So I think in that case, a tribunal that has got experience in dealing with such matters would be alive to the issue of potential unreliability of such evidence.
Thank you, Kokeng. Last question to you as well, if you don't mind. Sports is cross boundaries, cross borders, and boundaries are often blurred. And how does that work when it comes to enforcing arbitral awards? Is it the same as enforcing an arbitral award in a commercial dispute? Is it the same when it comes to a sports dispute?
Okay, so sports disputes can be commercial in nature because it involves a breach of contract between two parties relating to the sports industry, in which event enforcement of the commercial decision from a tribunal is quite straightforward. So if you go to court, it's a judgment. If you go for arbitration, it's an arbitral award. And typically, these awards are about payment of money. So it's a monetary award. So enforcement, it's the same as in any other commercial judgment or award. Now, but when you talk about decisions that are of a sporting nature, and by that, I mean one where, for example, a team is relegated, has points deducted because of breach of financial fair play rules. Something that has happened to Everton, something which many of us hope will happen to Man City. But if that is that scenario we are facing, or if, let's say, the decision is to ban an athlete for 8 years, for failing to give a blood sample or destroying his blood samples, as in the case of the Chinese swimmer some years ago. Now, these decisions are not capable of being enforced by a court. Well, sometimes it can be, because you can try to get an injunction to prevent him from swimming, but realistically, for all practical intents and purposes, these sanctions are self-enforcing. In other words, it's done by either the international federation or the national federation. So if an athlete is banned from the sport, then any organizer of the sport or any national federation that allows him to participate in it will in turn be sanctioned by the international federation. So it's the case of decisions of the FIFA dispute resolution chambers that hears disputes arising from breaches of FIFA regulations on the status and transfer of players. So if FIFA DRC gives a decision saying that this club is to be fined for unlawfully terminating the player's contract, then the way to enforce it really is not so much as to enforce it as an award under the New York Convention and then going to seize the club's property, but really, practically speaking, all the player needs to do is to tell FIFA, this club has not paid up the amount of compensation to me, and then the club can then be suspended from participation in all FIFA sanctioned competitions. So that's how sporting decisions are enforced, which differ from the way commercial decisions are enforced.
Thank you so much, Koking. You have perfect timing. The shot clock on the back just turned 0. But I would like to ask the organizers if we can have 5 more minutes just to take questions from the floor. Yes, if anyone has a question, can I invite you to the microphone in the middle? You can share your name, where you're from, and any questions for our 3 speakers over here. Yes, Thomas. Is it switched on? Okay, just hang on. There's someone coming.
Hello.
Ah.
Yes. Actually, it's more of an anecdote directly related to esports and doping in sports rather than a question. So all the speakers may relax at this point. And please, everyone, keep this story a secret because I may get disowned for it. We've spoken about cheating in esports in the context of Tekken, Counter-Strikes, which are perhaps games to which most people in the audience cannot relate. And that's why I want to share this story. It's a story about Scrabble and about my mom. Now, my mom is a keen user of a cell phone, of a smartphone, and she played Candy Crush for a long time, reaching level 16,532. But before that, she was a keen player of Scrabble. And every morning I would see her racking her brains over how to use her combination of letters to make the best word. One of her regular opponents was my uncle, her brother. And so they had a fierce competition whereby they had more or less, they were in a tie, they kept winning, they kept losing, but overall the competition was healthy. Every day they were excited to win their games. But one day, my mom, who is always at the cutting edge of technology, heard about an app. Using that app, she could take the letters she had been given, put them in the app, and the app would come up with the fanciest words in our case, French language. And she started using that app in her Scrabble competition, and she started winning. She racked all the points, and now it was 20 wins for my mom, 0 wins for my uncle. At the following Christmas dinner, my uncle inquired, well, have you been studying literature? How come you're able to know all these fancy words? And eventually he got to find out that my mom had that app. And a whistleblower may have played a role in that discovery, but don't tell her. So my uncle, being very cunning, downloaded an app, and it became more of a competition of who could place the fanciest words on the Scrabble board than who knew the fanciest words. And therefore the game was a bit denatured. They had reached a playing field, but the playing field was played according to different rules that denatured the whole game, and it became not fun. They stopped playing basically the following week because they were hitting each other with the fanciest words of the French dictionary. So to answer your original question, Leslie, you asked, is it the people, is it the technology that enables them? I think it's both. My mom, but I think it applies to many people, are naturally want to win when they participate in a competition. And if they can use a tool, an app in this case, that's easily accessible, that will not land them in the Scrabble jail, well, they will use it because they know they won't get caught, and that ultimately will break the game and not make it fun for anyone. So guys, please keep this for yourself. I don't want to get disowned after this. So please, I hope this is not recorded. Thank you.
Thank you, Thomas. Yeah. Anyone else would like to? I think we should be able to take 1 or 2 more. No. I will hang on for 10 more seconds. Oh, good. If not, I'd like to say a big thank you to our 3 speakers from the 3 different countries all across the Asian region. Thank you for being with us today, Koking, Abdul Rahman, as well as Yudis. Thank you.
Thank you to our panel of speakers and moderator for that engaging discussion. May I kindly request you to remain where you are. We would like to invite Datuk Sundra Rajoo to come up on stage to present the token of appreciation. Also like to thank Mr. Koking. We'll try and post our gift to you.
I will collect it the next time I'm in KL.
Before we proceed to the third and final session of our summit, let us take a short 30-minute break. We will resume the session here at the auditorium at 4 p.m. Light refreshments are served at the pre-function area, which is right next to our auditorium. We will see you all shortly.